has not been recorded.
Yes, yes.
Has
ma'am.
not been
Yes.
recorded. First of it is recorded that Mr. such and such and such
I
and
am
such.
Jagriti.
Please give the names. It has been submitted that Mr. such and such are represented the state. This is a election commission matter. State is also a party. Represented
Yes, sir.
the state on 23rd of July 2026. Let such error be rectified. This order shall form part of the order. Next. Down.
Item number 3.
Yes, 3.
Lordship, item number 3 and 4. Yesterday, I mentioned for the addition of names of learned counsel for the Election Commission of India.
All right. It has been submitted that the names of the learned advocates representing the Election Commission of India has not been recorded, though they appeared when the matter was taken up for hearing on 27th of July 2026. It is 27th of July 2026. It is recorded that the following learned advocates represented the Election Commission on 27th of July 2026. Bole naamgulo diye deben. Tapal let's such error. Next.
Grateful.
This is also same.
Yes, your Lordship. 3
Same-
and 4.
Same order date, 27th of July. Next.
Item number 5.
Yes.
Lordship, in the ordering portion, your Lordship has directed to disburse the money for direction upon the respondent number 3rd, Lordship, but it would be respondent number 2, Lordship.
It should be respondent number
2.
No, I have directed the treasury officer is respondent number
Yes,
4.
but the department has instructed me to, it would be respondent number 2, Lordship.
No, director of pension.
The principal account general, respondent number 2.
Who is appearing for the petitioner? Ratan Chandra Rai. Where is he? Respondent number 2 is principal accountant general.
Yes,
Item number
Lordship.
2 dijiye.
And the 4. Are you sure it's not the director of pension, provident fund and group
Yes, Lordship, I
insurance?
have got the written instruction, Lordship.
And Nitisha Vishwanath.
Where is Mr. Ratan Chandra Rai?
Ratan Chandra
You are
Rai.
here. Yes. What do you say? It should be principal accountant general.
Amount disbursed through treasury officer. Amount disbursed through treasury officer.
No, treasury officer is there. There are two directions. Directing the director of pension
Oh, my lord.
as well as the
2
treasury.
and 4. 2, my lord, 2 is
It should be 2.
2
Principal accountant.
accountant and treasury officer.
It has been uniformly submitted by the learned advocates representing the petitioner and the state that instead of the director of pension, provident fund and group insurance, the direction should have been passed upon the principal accountant general, West Bengal Treasury Building, being the second respondent. To start, let such an error be rectified. This order shall form part of the order dated 23rd July 2026. Yes, next.
Item number 6.
My lord, my name has been wrongly recorded as Dipan Pathak instead of Dipankar. That is the.
It has been submitted that the name of the learned advocate representing the state on 28th of July 2026 has been wrongly recorded. First of it is recorded that Mr. Such and such learned advocate represented the state on 28th of July 2026. Such error be rectified. Yes, next.
Item number 79.
My lord,
My lord, I'm late.
virtually, my lord. I beg to appear virtually, my lord. I am praying for extension of interim order, my lord. Interim order will expire on 11th August.
7 to 9, huh? Oh, I'm 79. 7 to 9.
I am praying for, my lord, extension of interim order.
Yes, I'm extending the interim order. The interim order is extended.
Supreme Court take it.
It's till 11th of August.
My lord, from 10th, my lord, there will be circuit. But, my lord, I am afraid
Yes.
there may be, my lord, some not to attend or any other. My lord.
It's 11th. Mr. Rai, it's 11th.
11, my lord.
So you can mention on 10th.
Yes,
It will
yes,
appear.
My lord,
Yes, on
my
10th.
application, my lord, if there will be any, my lord, not to attend or full court, my lord.
No, if there is
No, no.
anything, you also have 11th. You can mention on 10th.
Yes, yes, 10 and 11.
Yes, next.
My lord,
Item number 10.
I'm grateful, my lord.
I am for the petitioner also.
10, yes.
Your Lordship, the service upon the respondent number 7 to 10, written undelivered, Lordship. I have to serve again, Lordship. I'm praying for next, sir.
Respondent number,
7 to 10.
private respondent.
2 are private and 2 are,
What is this matter?
the matter is about my grievances against the marriage officer who registered marriage by completely.
The learned advocate appearing for the
Sir, this
petition
is
of
the
submission.
dispute between the husband, wife, petitioner before lordship.
No, no.
Her
Service is
mother-
not complete. Private,
Her
private.
mother married another person, he come before for the cancellation of marriage certificate. Marriage certificate cancellation, he has come.
My grievance.
How that is maintainable?
My grievance is against the marriage officer
Yes, how that is maintainable?
who comes.
How can you pray for cancellation of a marriage certificate of marriage held between two
Not-
other persons?
Not cancel. I am just.
That is what you have
raising this issue.
submitted. What have you prayed for?
I prayed for, Lordship,
Cancellation of the marriage certificate. Where is the marriage certificate?
marriage certificate is at page number. 14.
Samsul Islam and Shakina Begum. Who are you?
I'm the son of the Sakina Begum. The issue here is they have a spouse living
That's,
and there is a prohibition of marriage when there is spouse living.
who are you?
I'm the-
Shakina is not coming up.
I'm the
the
son of the.
Maybe. Let your mother come. The petitioner has challenged the certificate of marriage issued by the marriage officer certifying that the marriage between Samsul Islam and Chakina Begum, certifying the marriage between Samsul Islam and Chakina Begum. Full stop. Huh? Certifying the marriage. Certifying the marriage between. ঠিক আছে? ওই yes, what is, which page is the marriage certificate?
Page is at 14.
1/4.
1/4.
Between Samsul Islam and Chakima. Chakima na? Double C. Hakina. Page 14 এ আছে। Chakina Begum. Full stop. The learned advocate for the state raises an objection as to the maintainability of this writ petition. Full stop. The learned advocate for the state submits that such a challenge at the instance of a third party is not maintainable. Full stop. This court is inclined to accept the submission of the learned advocate for the state. Full stop. WPA number such and such. Accordingly stands dismissed. Full stop. It will, however, be open to the aggrieved party to take steps in accordance with law. Party, it will be open to the party aggrieved by the state. Yes, next.
No, 11 below, please, short
11,
matter.
yes.
Short matter.
Milord,
I am
for
paying
the-
only
I am for the
consideration my application.
Milord, I am
Before
for
the
the
Pradhan.
private respondent, Milord.
I am
Milord,
in
I am-
Application, consideration of the application of what?
cancellation of birth certificate.
Cancellation of birth
Birth
certificate.
Milord, I am for
Statement number
the
6, Milord.
private
Kindly take
respondent,
page
Milord.
21, Milord.
Milord, I am praying for Milord, some time, Milord, to get the instructions. Milord, I have received the brief, Milord, yesterday.
21.
Like Pradhan, Milord, to the Pradhan, Milord, who issue,
Certificate issued by the Pradhan.
yes.
Who are you?
I am the uncle of the
Uncle of the,
whose name is birth certificate issued.
How are you
Uncle of the
a
father.
how are you an aggrieved party? How
There's
can
a
you maintain
civil
this
suit
challenge?
pending.
Milord,
Milord, there's a civil
yes,
suit
Milord.
pending.
Milord, I am my father and Milord, the birth certificate issue, that date of the name of the father is the true father's name.
Maybe.
Milord, they died before that, Milord, they died after that, Milord, they issue certificate was issued after date of the
Mr. Ghosh, learned advocate, appears for
date
the
of my
private
uncle.
respondent.
Birth
He
certificate was
prays for
issued. after
an
long day,
accommodation
my lord.
to revert back with necessary instructions, full stop, this matter before the next available section. Yes, next.
Item number 12.
All state
Item
is
number
represented.
With
Item number
It is
12, I am
represented by his
budget-
landlord.
With instruction.
Yes, yes.
I am for the petitioner, my lord. May I be allowed to appear virtually, my lord?
Yes, my
Item
lord,
number
File the
triple,
lane.
12, my lord, Mr. Dugari is appear.
Oh,
Yes.
you are appearing,
Yes,
all right.
Yes, yes.
Yes.
My lord, in this
my
case,
lord,
what
in this
happened?
matter, Triple AG, Leonard Triple AG appearing, ma'am, my lord,
Yes.
I'll ask for a small Passover. He is busy somewhere.
Passover.
Yes.
No, this is the case covered by your lordship's order, my lord. Probably
Otherwise-
hearing was given before
My-
the date fixed for
All
reply.
right,
lord-
Passover,
Yes.
Passover, yes, next.
Then my lord, kindly fix it at 2 p.m. My lord, my lord,
30
kindly
minute
fix
I
it at 2
appear
p.m.
for the petitioner.
Passover,
My lord, he's
My lord,
engaged.
kindly
Yes,
fix
yes,
at
next,
2 p.m.
next.
At 2 p.m. my lord, kindly fix at 2 p.m.
2 p.m. may not be possible. Please see whether.
Item
it can
number
be taken
13,
up.
my lord,
But
item
But
number
30
13.
minute I appear for
13 I
the
appear for
petitioner.
the state.
Yes, 13, who is appearing?
My lord, I am
But I
led by
appear for
Mr.
the
Shivaji
petitioner,
Kumar
my lord.
Das. He will be
My lord,
appearing.
Yes.
in this matter,
My lord,
I'll be
this
needing,
matter
I
my
have sought for
essentially
instructions,
pertains
my
to the
lord, yet
West
to come.
Bengal Administrative Tribunal. But my lord, lordship knows, my lord, the administrative
Yes, yes.
tribunal is not functioning now. Now, my lord, what my prayer is, my lord, I have made an application for transfer, but I am a Group D staff in the office of the subdivisional officer Karsiong. Now, my lord, my father died. My lord, my mother is ill. On that ground, my lord, I had made an application for transfer. My lordship kindly takes up, my lord, page 24.
What happened to that application?
My lord, page
What
24.
happened to that application?
My lord, kindly takes up page 24 once.
Pending.
24 years.
My lord, kindly sees, my lord, they had sought for 3 clarifications. First is whether any
All right.
vigilance court case remains pending. My lord, my instructions are it is in my favor. My lord, whether any outstanding is pending, that is also in my favor, that there is no outstanding pending. The only issue is, my lord, the district magistrate is not issuing me a no objection certificate.
Yes.
So we have to get a report, my lord, in this matter.
My lord, only
Regarding
issuing,
the,
DM is not issuing a
status-
no
regarding
objection
the
certificate
status
for
of
which
the
I am not getting
inquiry.
transferred.
That confidential report which was asked for, my lord, I have to get a report on that, my lord.
All right. You want to file a report?
Yes, my lord.
The petitioner alleges that the prayer of the petitioner for transfer from the
But office of the
office of the district magistrate and collector Darjeeling
No,
to
he's at-
to
My lord,
Well, district magistrate
He's
and collector
presently-
Murshidabad.
my lord, he is presently, my lord, I think
But I am working
subdivision
as a
at
group
the
D
office
employee
of
in SDO
subdivisional
office,
officer
Karsiong.
Karsiong.
now he wants to go to the Murshidabad.
Yes,
Murshidabad.
office of the district magistrate and collector
Acha,
Murshidabad.
কেটে দিয়ে লিখুন। The petitioner who is presently serving as a Group D staff in the office of the subdivisional officer Karsiong, district Darjeeling, has sought for a transfer to the office of the district magistrate Murshidabad, which is the home district of the petitioner. So stop. The learned advocate appearing for the petitioner submits that such application is pending consideration before the
District magistrate, Darjeeling.
And collector
is,
Darjeeling.
before the district magistrate Darjeeling. First up paragraph, Mr. Bhattacharjee, learned additional government pleader seeks an accommodation to revert back with necessary instructions. Let a report be filed by the district magistrate and collector Darjeeling disclosing his stand with regard to the prayer of the petitioner.
Great.
Let such report in the form of an affidavit be filed.
Let it be report, my lord. Just a report.
Affidavit দরকার নেই, report within
1 week.
on or before August 7,
My lord.
2026, list this matter before the next available circuit bench, subject to the convenience of the honorable
My
judge.
lord,
Grateful,
my lord,
my
may I
lord.
get an
Next.
advance, my lord, may I get an advance copy of the report from Mr. Bhattacharya?
Upon supplying an advance copy of the said report to the learned advocate for the petitioner. Yes,
Grateful,
next.
my lord.
Yes,
14 Lordship, I am for the petitioner.
yes.
Here the matter is acquisition matter. My land has been acquired, but
When it was acquired, under what statute?
notice has been given, notice in page number 16. 16 and
16,
16 and 17. Thereafter, they have also issued payment notice also.
This is Petroleum Act.
Yes.
Who is appearing for the petroleum company?
Lordship state is representing.
State is, you are the
Yes,
competent
yes,
authority,
Yes, Lordship.
but
Lordship,
you-
kindly
if-
seize the page number 24, Lordship.
And 18th payment, my grievance is they have not given me the full and lawful
have
compensation.
you served upon the
Yes,
respondent?
I have served, I have,
Lordship, I am the
NRL.
answering respondent, Lordship,
NRL,
because he
NRL,
is
yeah. I have
saying
served.
that he has not received the compensation. Lordship, the authority is the special land acquisition officer. So
Uh,
the state is representing.
the
My representation may be considered, it is in
page,
page
Page
24,
24, Lordship.
24 and
24.
19. 19 is
But-
to the NRL and 24 is for the DM. 19 and 24.
But in the later Lordship, he himself admitted that his brother has taken away the compensation, Lordship.
Is
Kindly
it
see-
so?
Yes, Lordship.
And my grievance that I am the exclusive owner.
Then
So
that
this should-
dispute, where is that act, petroleum, that act?
Lordship,
Then it has to be
the
referred to
competent
the,
authority, Lordship,
My share also I have not taken.
sir, then that dispute has to be referred by the competent authority, I think, before
Then-
the principal civil judge.
My
No, Lordship,
representation may,
there is,
at least my
there is no
representation
provision
should be
to refer this
considered.
matter to the principal civil judge, Lordship. The competent authority is specified under this act,
No,
Lordship.
no, competent authority is specified, but if there is a title dispute,
No, no.
can you
Lordship,
decide
there is no
that?
The
title
civil
dispute.
court has no jurisdiction, Lordship. It's clearly specified in this act, Lordship.
Please show me,
I'm sorry, Lordship.
But I faintly recollect because I had dealt with this matter, there is a provision for reference. I do not know which is the authority. Do you have that act?
Yes, Lordship, but in my phone, Lordship.
Yes, yes, give me that. Who is for the petroleum company?
निकालो। अरे ये नहीं तो लैंड एक्विजिशन क्यों देख रहे हो? क्या बोलिए जिसको मैंने दे दी है पेट्रोलियम। In the bottom of the act, Lordship, most probably in 14, Lordship, there is specifically stated that civil court has no jurisdiction in this. तुम अभी पढ़िए, just 2 minutes पहले।
District Judge, madam, I told you there is a provision.
Just now I see the act, Lordship.
Then you told that civil court do not have jurisdiction.
Section
Section 11. So I told you that I've dealt with this act. I know initially it has to be the, have you submitted a representation before the competent authority?
yes.
Where is that?
That is at page 19.
Because section 11(3) says this relates to deposit and payment. If the amount of compensation amount under section such and such deposited by the central government, the state government of the case may be the competent authority within such time. If the amount of compensation is not deposited, then 3 is as soon as maybe after the compensation has been deposited, the competent authority shall on behalf of the central government pay the compensation. Where several persons claim, it's this case, where several persons claim to be interested in the amount of compensation deposited under subsection 1, the competent authority shall determine the person who in its opinion are entitled to receive the compensation and the amount payable to each of them. If any dispute arises as to the apportionment of the compensation or any part thereof, or as to the person to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the district judge, within whose limits of the jurisdiction the land or any part thereof is situated, and the decision of the district judge thereon shall be final. That is why I told you, this title dispute cannot be decided by those authorities. Ashun, where is your application?
Application.
Have you raised that dispute?
Yes, I raised. Page
Where is
19.
that?
Page 19. Page 19 and page 24.
And what is your instruction? Compensation has been paid
But
To
not
the
full
brothers'
paid.
to
instruction,
the
I
other
have-
brother. That is your instruction.
No, Lordship, I have not received a brief. We got the brief yesterday, Lordship. We have not received the instruction, Lordship.
So from
But
where are you
his
saying that
letter-
compensation has
By
been
his
paid?
letter, Lordship.
Where is that? Please show me that. Oh, certain other legal years.
Lordship, compensation not completely paid, Lordship. Kindly, they have not replied my representation.
All right, I'm directing. Yes. The petitioner alleges that the plot of land petitioner claims to be the owner, claims to be the recorded owner of certain plots of land which has been utilized for the purpose of Paradip-Numaligor crude oil pipeline project. Full The grievance of the petitioner is that the amount of compensation money has not been disbursed in his favor, and the same has been paid to the other legal heirs of his father. First up, petitioner submitted an application before the competent authority under the Petroleum and Minerals Pipelines within bracket Acquisition of Right of User in Land bracket closed Act 1962 by a later dated 11th of February 2026. The learned advocate appearing for the petitioner submits that in spite of receipt of such representation, no steps have been taken by the competent authority. No decision on such representation has been communicated by such authority to the petitioner till date. First up, Ms. Singh Learned, junior government advocate submits that the decision on the said representation shall be communicated to the petitioner within the time limit as indicated in the said representation. First up, after going through the claim made by the petitioner, after a cursory glance to the representation dated 11th of February 2026, it prima facie appears to this court that the petitioner has raised a dispute as to the persons who are entitled to the compensation amount as well as the apportionment thereof. Yes, please open that. It is in the
Sorry, Lordship.
section 11. Please give me section 11. Section 11 of the 1962 Act deals. Section 11 of the 1962 Act deals with deposit and payment of compensation. Subsection 3 of section 11 states that as soon as maybe after the compensation has been deposited under subsection 1 within brackets, the competent authority shall, on behalf of the central government, the state government of the or the corporation, as the case may be, pay the compensation to the persons entitled thereto. Full stop. Subsection 4 of section 11 states that where several persons claim to be interested in the amount of compensation deposited under subsection 1 bracket the competent authority shall determine the persons who in its opinion are entitled to receive the compensation and the amount payable to each of them. Full stop. Subsection 5 of section 11 states that if any dispute arises as to the apportionment of the compensation or any part thereof, or as to the persons to whom the same or any part thereof is payable, the competent authority shall refer the dispute to the decision of the district judge within the limits of whose jurisdiction the land or any part thereof is situated, and the decision of the district judge thereon shall be final. To stop, as observed herein before, that there is a dispute as to the persons who may be entitled to receive the compensation and the amount payable to each of them. First up paragraph. Since the said dispute involves adjudication on facts, this court feels that the said issue should be left open to be decided by the authorities under the 1962 Act. First up paragraph. In the light of the submissions made by the learned advocates for the respective parties, and without entering into the merits of the claim made by the petitioner in the representation dated 11th of February 2026, WPA number such and such stands disposed of by directing the competent authority under the 1962 Act being ... respondent to consider the representation of the petitioner dated 11th of February 2026 and shall determine the persons who in its opinion are entitled to receive the compensation and the amount payable to each of them. So, if in the opinion of the competent authority, any dispute arises as to the apportionment of the compensation or any part thereof, or as to the persons to whom the same or any part thereof is payable, the competent authority shall take necessary steps in accordance with the provisions of section 11 within bracket 5 of the 1962 Act. To start, the entire exercise by the said respondent shall be completed as expeditiously as possible, but positively within a period of
8 weeks, Lordship.
8 weeks. Within a period of 8 weeks from the receipt of a server copy of this order, together with a copy of the representation dated 11th of February 2026.
Can it be 4 weeks instead of actually
4 weeks?
4 weeks? Not so, because
Sir, they have to issue a notice to the other side. All of you have to appear. Then if the competent authority can decide the dispute, it's well and good. Otherwise, then it has to be referred to.
let's say opportunity of hearing.
That will be there as per the dispute, that will be there. अच्छा, 6 weeks kore do.
I'm ready.
6 weeks.
Yes, I'm good.
8 to 6.
Section 14.
Yes, next. Call the next matter.
Item number 15.
Yes.
Not done petition.
Yes.
But
So
2006.
fruitful appearance. Coming to the circuit bench, so purpose served. Yes, Mr. Bharat.
2006 petitioner was appointed as assistant teacher in the district of Jalpaiguri, my lord. Though he is the resident of Murshidabad. So for getting better opportunity, he again appeared in the first SLSC 2016. My lord, he was recommended in Murshidabad. Now, my lord, 2025.
Initially in Jalpaiguri.
Yes, my lord.
Then second time in
Yes, he got
Murshidabad,
yes,
home district.
home district.
Yes, now what is the
Now,
problem?
2025, all appointment has been cancelled. First SLSC Lordship Hyderabad.
Now you want to go back. Now come to
Immediately
this.
after cancellation, as per order of the Supreme Court, I made prayer. Kindly
That
recommend
is not
me.
being considered.
Yeah, that has been considered, but recommend me again in the district of Jalpaiguri. In
It has
spite,
to be done.
yes,
because,
but, I made several prayers. Well, my wife is suffering from serious illness. That's why I made representation. My only prayer is let it be considered. Nothing else.
Mr. Bari, can
Let
it
it be
done?
considered, madam.
Because then what remains? Then you are in
My
a
request-
roundabout way, you are coming to the second which has been set aside.
No, there are existing so many existing vacancies.
Maybe.
Several.
Maybe
in the
but-
several
but
matters
now
of-
you are going to the first appointment, so that has to be in that circle. Otherwise, it will be bypassing. Mr. Bari, it will be bypassing the order.
Madam, not Malat. I am praying for. I've joined there. I'm not there. I've joined there. Joined here. I'm working. Malat. My
Then
prayer.
you want
Made
transfer
prayer. Malat. I consider my prayer. Malat, by the
for
Commission-
transfer.
Commission of School Education. For re-recommendation, in the coordinate bench, similar situation, coordinate bench parts order, the authority have also considered several cases. My only prayer, let it be considered. My representation is at page
generally
42,
appear on
for
the
the
School
statement.
Service Commission.
page 42.
Yes,
In
Mr.
this
Rai,
matter-
what do you say?
My lord, if he has joined in the post, my lord, she can make an application for transfer, and if she makes an application for transfer, the appropriate steps shall be taken in accordance with law.
Commissioner of School Education be considered. I'm not praying for
Malat,
that.
Application for transfer, Mr. Bari, that would be better. Re-recommendation to that, it's bypassing Mr. Bari. Cannot be done.
Several
if-
cases they have
If
done.
she has
also,
not been.
In the several,
Bari-
there are several examples they have done.
But because otherwise, what is the effect? So, roundabout way, Mr. Bari, it's bypassing that order. Because
Malat,
There
now
are several
please
examples
consider-
to that.
Please consider, there are two things. One is, there was a recommendation initially. So by virtue of a recommendation, you were appointed to a particular school. Now, yes, you have a right to participate in the subsequent examination. So you participated in that. So you got another better opportunity according to you,
My lord.
accessible opportunity, you have gone there. Now, good, bad, indifferent, that procedure has been now
Yes,
set
my lord.
aside, cancelled. So that goes. So now you want to persuade to an observation in one paragraph 42 or 47 of that
47,
judgment. So
But in that
40
paragraph,
42 or 47.
yes, my lord.
Yes.
In that paragraph, Honorable Supreme Court never says that you have to recommend to the school where he was earlier appointed. Only revert back.
Mr. Mr. Bari, if you invite observations, I can give that. What is the effect of that? The effect of that paragraph observation is that you'll be entitled to that appointment. That appointment means there.
Yes, but that have
Then,
also,
Mr. Bari, you will be
they also
difficult-
diverted from that point also. They have not given appointment to that particular school. They have given appointment to another school.
Mr. Bari, cannot be done. Cannot be done. For that is consideration. Cannot be done. Can it be done? The person who has been appointed in your place, because you took an advantage there. Somebody has taken advantage there. He has been transferred because it was vacant. Now, can it be again thrown out? So you will be accommodated in a nearby school. That they will do. That they have done. And you have got the job. Otherwise, please consider you would have lost the job. Technically, Mr. Bari, you have
several
got an
cases-
advantage. Technically, you should have lost your job because you have taken a conscious decision. So that is the benefit given only for this situation. Unfortunate situation. I
know. That's why. But,
unfortunate situation.
but-
This has been done. So to give you, otherwise, in a practical situation, you would have lost your job.
Malat,
but in identical
coordinate-
situation, they have already considered several cases. That's not the case.
Malat,
They have not
coordinate
considered
bench
any
is
other
directed
case.
for consideration.
Malat, they have already considered several cases. I have several examples to
Malat,
that effect. That they have given effect.
may I assist your lordship, Malat? May I assist your lordship, Malat?
Yes.
Malat, order for consideration was passed by the coordinate bench only on the such cases where the petitioner had not joined the post, re-recommended post, and prior to joining, they have approached the
So he has
commission.
joined.
He has joined, so he's my lord. Presently, the relief of the petitioner is to pay for the transfer application through the online portal.
Mr. Bari, what do you say? There's a
And the
distinction. He says.
coordinate
In those
bench,
cases, they have
in
applied
Bari-
prior to that, re-recommendation.
No,
Now
but
you have joined.
I have the example also, but even after joining, they have second time recommended.
Malad,
But
in
very
two
well,
cases-
Lordship kindly grant me liberty to apply for transfer, and that will be
Yes.
considered in accordance with law. Kindly that liberty may be granted.
I
Yes,
think
madam.
that's better.
Very well, very well, madam.
And in Mr. Bari's matter, a similar order was passed by coordinate bench. Prayer for transfer.
Transfer.
Yes, ma'am.
Mr. Bari, please give me the facts. When do I get the initial
Malad,
facts?
Yes, Malad. 2006,
Which paragraph?
paragraph 4, page 3, paragraph 4, first appointment.
That was your first appointment.
First appointment, 23rd
Uh,
February 26.
That was
two-
your first appointment.
2006.
Then
Second
Uh,
appointment, paragraph 6, Malad.
second appointment, 2016 SLST.
Yes, Malad. Seventh,
Joint service on 7th of February.
7th February 2019.
Yes. Then that was set aside.
Yes, Malad.
Then paragraph 7 is the Supreme Court's judgment.
Yes, Malad.
Then,
7 and 8 to Supreme Court judgment. I have also quoted paragraph 8.
all right. Then you have
Thereafter-
applied
Malad.
pursuant to that.
Yes, paragraph 11, third recommendation.
Paragraph 11 is,
Third recommendation, Malad.
yes, now you have joined Satkura High School.
Yes, 19th November 2025, I have joined there.
Yes.
Page 35 is the recommendation letter, Malad.
Joined this new place of posting on 19th.
Yes, Malad. 19th November 25. Malad. 35 is my recommendation letter, Malad. 30, page 35.
All right. Please, here if there's any mistake in facts, please correct me. Petitioner was selected and appointed as an assistant teacher in of bioscience undergraduate category pursuant to the recommendation of the West Bengal Regional School Service Commission dated 23rd of February 2026. Full stop. Pursuant to such recommendation, petitioner joined his service in Potkapara High School in the district of Jalpaiguri. Full stop. The petitioner claims to be a resident of Kandi in the district of Murshidabad. Full stop. The petitioner participated in the subsequent recruitment process undertaken by the School Service Commission pursuant to a notification issued in the year 2016 for first SLST, first of 1ST. ঠিক আছে? First মানে ওই 1ST SLST full stop. The petitioner was selected and recommended for appointment in Boranagar Rani Bhavani Vidyapit within bracket HS at Azimganj in the district of Murshidabad. So stop. Petitioner joined his service at the said school on 7th of February 2019. So stop. However, the appointment of the teachers pursuant to the first SLST 2016 was set aside, and the Honorable Supreme Court by an order dated 3rd of April 2025 in civil appeal number SLP within bracket C -9586 of 2024. Mr. Bari, the numbers are correct.
Yes, yes, ma'am.
You have checked up in the case of the state of West Bengal versus Boishaki Bhattacharjee within bracket Chatterjee and others.
Paragraph 8.
Gave liberty to the appointed teachers to approach the respective government departments or bodies within a specified time frame to resume their positions. First up, pursuant to such liberty, petitioner applied before the School Education Department, Government of West Bengal, praying for reinstatement in service pursuant to the order passed by the Honorable Supreme Court. First up, petitioner was thereafter recommended was recommended to the post of assistant teacher in Satkura High School in the district of Jalpaiguri. First up, the petitioner, now you have made a representation.
Yes, my lord.
Where is that?
That is my lord, page 42.
The petitioner submitted a representation before various authorities, including, now who has to consider that?
Transfer.
No. This prayer.
But this prayer, my lord, Commissioner of School Education.
Commissioner,
Because vacancy is lying with the Commissioner of School Education.
submitted representations before various authorities, including the Commissioner of School Education. Your prayer is also transfer. In this representation, prayer is also transfer to a school.
My lord, in case of transfer, my lord, the School Service Commission is the appropriate authority.
Mr. Bari, your prayer is for transfer. Please see your application.
I have also made prayer to the chairman of the School Service Commission also. Let it be considered.
And my lord,
No, you have
the-
made, but
the transfer
then I
application
can
must be the
direct
paper.
consideration of this prayer for transfer. You
No,
did
my
not
lord.
submit another application.
Yes,
No,
my
my
lord.
lord, it is not permissible under
Then,
the law, my lord.
Mr. Rai, who is
It
for
is
the
not-
state, they will not take any objection that through Utsav Street was not
My lord, and
submitted.
transfer application must be
No,
Through
you will
the
be covered because I think at
Yes.
that point of time, Utsav portal was not functional.
Yes, ma'am.
2nd of February. All right.
my lord, it must be
you know-
my lord, in the prescribed format. And it must include
But
the
Mr. Rai,
NOC.
at that point of time,
Malad,
the portal was not functional.
In offline
Don't
also,
be
my lord, there is.
No, don't be so technical. Not on form, he has applied. Please consider that.
My lord, then
Don't
kindly
be
direct
technical
the
in all this.
Commissioner of School Education, my lord.
Yes. কি বললাম? আচ্ছা, including the Commissioner of School Education Department as well as the Chairman, West Bengal Central School Service Commission, praying for recommending the petitioner to a school in the district of Murshidabad. First up, paragraph. Mr. Rai Learned Advocate appears. Mr. Bari Learned Advocate appearing for the petitioner submits that since the petitioner is a resident of the district of Murshidabad, it is difficult for her to
His, my lord.
his acha for him কি বললাম is a resident of Murshidabad. It is difficult for him to perform his duties as an assistant teacher in the district of Jalpaiguri as his wife is suffering from
Yes, my lord.
as his wife is suffering from various ailments.
Right.
First up, paragraph. He submits that the authorities of the School Service Commission be directed to recommend the petitioner to a school in the district of Murshidabad. First up, paragraph. Mr. Rai Learned Advocate appears for the School Service Commission. First up, he submits that the petitioner cannot pray for re-recommendation to the district of Murshidabad as his earlier place of posting was within the district of Jalpaiguri. And the subsequent appointment within the district of Murshidabad has already been set aside by this Honorable Court and not interfered with by the Honorable Supreme Court. First paragraph, heard the learned advocate for the state. First up, faced with such submission, Mr. Bali, learned advocate appearing for the petitioner, submits that in the representation dated, what is the date?
2nd February 26.
In the representation date is not 2nd February. It was received on 2nd February. The representation which was received by the no, Mr. Bari, this stamp is of the secondary education, Commissioner of School Education.
I send it to the all the authorities. I send it to the all authorities.
received
I am
on
assuming,
2nd.
yes. On 2nd February itself.
কি বললাম? Faced with such submission, Mr. Bari, learned advocate appearing for the petitioner, submits that the petitioner has sought for transfer to a school within commutable distance from his home by and such representation was received by the Commissioner of School Education on 2nd of February 2026. Full stop. This court can take judicial notice of the fact that at the relevant point of time when the prayer for transfer was made, the Utsoshri portal was not functional. Full stop. Paragraph that was at that time, I think that was not functional. Full stop. Paragraph. In the light of the submissions made by the learned advocate for the respective parties and taking note of the submission of Mr. Bari, that the petitioner is inclined to press his prayer for transfer from the school where he is presently serving to a school in the district of Murshidabad. It's an inter-district. Who will consider?
Not only authority, but the commissioner will recommend, forward it to the chairman School Service
Commissioner,
Commission.
since the
School
commissioner
Service
has
Commission
the-
will recommend it.
My lord, since my lord, the
Commissioner is
commission-
to take a decision.
Yes, my lord. Kindly direct the Commissioner of School Education.
Commissioner send it to the School Service Commission.
The Commissioner of School Education Department being the
Respondent number 2 perhaps. Respondent number 2.
being the second respondent is directed to consider the prayer of the petitioner sympathetically and dispose of the same in accordance with law. Any provision for opportunity of hearing in accordance with law after affording an opportunity of hearing to the petitioner or his authorized representative and by passing a reasoned order as expeditiously as possible, but positively within a period of 4 weeks. 4 weeks from the receipt of a server copy of this order, together with a copy of the representation dated 2nd of February 2026. Full stop. If the in the event the Commissioner of School Education decides in favor of the petitioner, all consequential steps thereafter shall be taken as expeditiously as possible.
Yes, deeply.
Thank you.
Great.
Yes, next.
60.
Yes.
My lord, I'm for the state, my lord. Answering respondent is the School Service Commission, my lord. This is the inter-district transfer application.
Yes, what is this case?
Yeah, this
Same.
also, no, it's a transfer, my lord. It's a
No,
pure
this
case
is,
of transfer, my lord.
Only transfer?
Yes, my lord. The petitioner is the resident of Nodia, but he was appointed in Dhupguri, in the district of Jalpaiguri, 500 kilometers away. My lord, his wife was suffering from
Where is
serious-
your application?
Yes, my lord. I applied for transfer. Thereafter, medical board was formed. My lord, page 98, can you see? 98 and 99. Medical board was formed.
What is the opinion of the board?
Yes, that's my prayers. There is no opinion from the authority concerned. That's why my lord, my application has not been processed till date. What is the fate of my medical.
Only constitution, medical board has been
Yes, I
constituted.
knew, I also appeared, on page 100. I also appeared pursuant to the requisition before the medical board. But what is the report? They have not disclosed till date. That's why I'm also not being able to apply afresh also.
Yes. But why have you not decided this from 2022?
Yes,
My
my
lord.
My lord, since my lord,
I
the
cannot make a fresh
pending-
application.
issue is pending since 2022, and my lord, the transfer application since pending in the portal. So my lord, he will not be permitted by the portal automated. He will
Yes,
automated-
that's the
will
difficulty.
not
I
be
cannot make
permitted.
fresh
So
application.
my lord, kindly
Portal is
direct
every
the district-
time is saying his application is
kindly
pending.
direct the district inspector of school to take appropriate steps, and if medical board suggests for a transfer, kindly forward the same transfer application to the school service commission for final consideration.
Now, medical board has been constituted long back. Mr. Bari, I think now a fresh board has to be constituted. That persons may not be there now, who was constituted at that point of time. 2022, you're in 2026.
Six.
Medical board, maybe the government doctors, they are also being transferred.
And petitioner may have.
You are
my
paying
lord,
for transfer,
Or
they are also paying
or
for transfer.
alternatively, your lordship can direct grant me liberty to make a fresh application offline, because online I cannot make
No, my lord.
application. Whenever I making
Present-
application,
presently
online
stands
sir,
the end of the
Right,
government
what is the
there, my lord.
difficulty? I think that is better.
yes, my lord.
If he does not want to proceed with that, he can make a fresh application.
My lord,
What is the
then, my
harm?
lord, kindly direct the district inspector of school to reject her application and allow him to, my lord, because my lord, it will again, my lord, open
No,
a
if I can,
floodgate.
Mr. Rai, if I record Mr. Bari's submission that he will not press this application for transfer, we with liberty to apply a phrase.
But I cannot apply in
Yes,
one
my lord,
portal, because
without
whenever I
mentioning
making
online
application, portal is saying your application is pending.
I can record that. No, if I record that, then you can apply.
But then
I
have to
record
apply-
your submission.
Then I have to apply offline.
Why?
Because
my lord,
online
that
I
is not-
cannot make application because when
No, if I record your submission that you will be not pressing this application, I record your submission and hold that application is rejected, give you liberty to apply.
Malan,
after-
even
Yes,
then
my
the
lord.
portal is not permitting. Portal is not permitting. Portal is saying your application is pending.
No, after this order, there is.
No, they will not change it. They will not
Why?
change it. That's
Who-
the
My
whole
who
lord,
is
difficulty.
manning the portal?
The
district
DI
inspector of school,
Office of the District
kindly
Inspector.
direct the district
Then
inspector
what
of
should
school
be
to
done?
reject his application. Kindly
To
di-
reject?
I'll direct the district
Kindly
inspector to
direct the
return back
district
my
inspector
application,
school-
then apply, I can apply.
Then
Yes,
you can
madam.
apply.
If you return back
Yes.
my application to the
Yes,
school
what do you
authority,
say?
then I
You
can
return
apply.
his application, I record his submission that he will be
Yes.
withdrawing his application.
Yes,
Uh,
my lord.
Very well, madam.
Yes, my lord.
Then there will be no
No,
difficulty.
no, yes, madam. If
Then there will be no.
If the application is
because
returned
from
back, then I can apply.
2022,
Or my lord can allow me to make offline application.
No, my lord, that is not permissible.
offline, Mr. Bari, I do not know when it is a system of online. they
Yes,
will
madam.
be
Very,
saying
very well.
you
Well,
will
let
be
them,
facing
let them,
problem.
let them return it back, my lord, so that I can apply fresh.
Yes, what do you say?
If my lord, if he want to withdraw this application, lordship,
Yes.
then that may be.
Yes, where is Mr. Vadayaji? Please assist me. In this matter, you have the copy. Please
Yes.
kindly come to page 98. Mr. Bari's client has filed an application for transfer. Filed an application for transfer.
My lord.
Now, on medical ground. So medical board was constituted. See page 98. In 98, a medical board was constituted on 26th of September 2022. But till now, no opinion has come. Now, one thing is to direct the DI to complete that procedure, but it will be a longish one because that board may not be now present. So
Yes,
again,
madam.
a fresh constitution and another thing. So Mr. Bari now wants, he will withdraw this application because the time, if that is pending, he cannot again apply. So he will be applying, he will approach you, please, for withdrawal, please return back that application,
Through online,
Make-
through online portal.
return through online, that is
Yes, yes,
permissible.
yes, yes.
Yes,
that is
madam.
permissible.
Yes.
I'm not
I don't know.
aware.
Yes, yes, that is permissible.
That is Mr. Rai is also saying it's
Very well, then
permissible.
it is.
So you return that, I'm recording that, then he will be, make certain, those arrangements in the, if it is online, then the portal can accept. Otherwise,
Otherwise,
if you
it
give
cannot.
it offline, the portal will not know.
Yes, my lord.
So I'm passing that order.
Yes, madam.
আসুন। The petitioner, where are the facts, Mr. Bari?
The first appointment is that, my lord,
First is this the only appointment?
yes, only appointment.
The petitioner was appointed as an
Paragraph 4, I have
assistant teacher,
stated, I am the resident of
was
Nadia.
appointed as an assistant teacher
Paragraph 4, my
in
lord.
Horinkawa Ellen High School in the district of Jalpaiguri, pursuant to a recommendation of the West Bengal Regional School Service Commission, Northern Region, dated December 21, 2013. So stop, the petitioner joined the said post and is serving at the said post till date. Full stop. Petitioner claims to be a resident at Bhimpur in the district of Nadia. Full stop. The petitioner applied for transfer on special ground before the school authority through online portal within bracket within inverted comma Utshosri, along with all relevant documents. Full stop. Full stop. Mr. Bari Lanet, advocate appearing for the petitioner, submits that pursuant to the application for transfer, a medical board was constituted as per the request of the district inspector of schools within bracket SE Jalpaiguri. Full stop. He submits that till date the medical board has not given its opinion. Full stop. Paragraph. Paragraph. He further submits that the application for transfer is pending for a long time, and unless a final decision on such transfer application is taken, the petitioner cannot also apply afresh for transfer. Mr. Bhattacharjee Lanet, additional government pleader, appears for the state. Paragraph. No.
I'm sorry to interrupt, my lord. Page 100, my lord.
Yes.
It says the list of the applicants who will appear.
Yes, he appeared, but the opinion has not been given till date.
That part remains, so your lordship was pleased to observe what is following.
Yes. আচ্ছা ওইখানে না মিস্টার বারির সাবমিশন আর একটা রেকর্ড করে দিন. He submits that on the date specified by the medical board, the petitioner appeared and no, you appeared or your
my wife.
The wife of the petitioner appeared before the board, but no final. Final decision but no final decision has been given by the final decision. Final opinion of it. Final opinion has been given by the medical board. Full stop. Mr. Bari submits that liberty be given to the submits that the district inspector of schools be directed to what they will do?
To return my application
To
through online portal.
return the transfer application of the petitioner through online portal, so that the petitioner can apply afresh through the online portal. Full stop. Third, Mr. Bhattacharjee Lanet, additional government pleader. Full stop. Mr. Rai Lanet, advocate, appears for the School Service Commission. Full stop. Paragraph. After considering the fact that the matter is pending before the medical board since 2022 and more than 4.5 years, 3.5 years have already elapsed since the appearance of the wife of the petitioner before the medical board, and no opinion has been given by the medical board till date. This court is of the considered view that no useful purpose would be served in directing the medical board to give its opinion at this point of time. Full stop. This court, after hearing the learned advocates for the respective parties, this court feels that the interest of justice would be subserved if the district inspector of schools, secondary education Jalpaiguri, is directed to return the transfer application of the petitioner through online portal as expeditious within a specified time frame, and the petitioner is given liberty to apply afresh through the Utsosri portal. First a paragraph, in the light of the submissions made by the learned advocates for the respective parties, WPA number such and such stands disposed of with the following directions. Number one, the district inspector of schools within bracket AC Jalpaiguri is directed to return the transfer application of the petitioner dated any number, date, where it is, where do I find that?
Yes, my lord.
Dated such and such, number jodi take such and such, as expeditiously as possible, but positively within a period of
13
10
September,
working days.
13 September
10 working
2020.
days from the receipt of a server copy of this order, server copy of this order. Full stop. Next, number two, upon return of such transfer application, comma, the petitioner shall be at liberty to apply afresh through the Utsosri portal in prescribed format. Full stop. Next, if the petitioner applies afresh through Utsosri portal pursuant to the liberty granted by this court, comma, the same shall be considered by the concerned authority in accordance with law as expeditiously as possible.
Good.
Anything more, Mr. Bari?
Since petitioner's wife is suffering from severe medical illness, that will be considered while deciding the issue.
That is the on medical
Yes,
ground.
yes.
That is what is the date and the number?
Yes, my lord. My application date was 8 July
Where
2022.
do I find it? Have you
My
stated
lord, page
anywhere?
97, page 97.
97.
My lord. 97, serial number 6. Applicant to head of the institution.
Page 97,
Serial number 6. 8 July 2027, applicant to head of the institution.
So there is no number. Only
No
the
number
date.
is there. It's an online portal statement. This is a statement of online portal.
So if this date is only given, they can track this.
Yes, my lord. Yes, my lord. This statement, they can track this. My lord. My lord, it was reached to the head of the
They
institution.
can
the
track
DI,
through
my lord,
the
on 20
employee ID. They can track through employee ID.
Employee ID is also there.
Employee ID, where is that? Where do I find the employee ID?
Malab, kindly see the code. Welcome, Raju Halda, then thereafter code.
Then code.
Yes, Malab, this code will, Malab,
CUZ.
yes, Malab.
Yes, madam, that is the employee ID.
Acha. Dated eto being code number eta ke na dekhe niya dekho page 97.
Very good. Develop.
Yes, next.
Affidavit of service.
Sorry, Mr. Bhattacharya.
Affidavit of service.
Yes, every service taken on record. Yes, next.
Item number 17, Malad.
Yes.
It's the Malad SIR matter, but
SIR.
yes, but Malad kindly, Malad. This is some urgency at least there.
Yes, past elections.
No.
Your Lordship, I appeal for Election Commission of India.
Yes.
Lordship, I am appealing for estate. The matter is pending before the Honorable Tribunal.
Yes, yes.
Yeah, Malad kindly, Malad paragraph 11. Malad
Paragraph
petitioner
11.
participated in the two recruitment process. Malad result may be published at any point of time.
Your Lordship could pass the usual order giving time frame of 1 month.
Ms. Pandey, only one thing, I'm passing usual orders in other matters. But here there is a recruitment at
Yeah,
any
Your
point
Lordship
of
can
time,
give
the
the time
result.
frame of
Can a
1
shorter
month.
time be given?
Your
Shorter
Lordship.
time be given? What would be the
Yes.
reasonable time?
It's identical matter. Miss Pandey
1
appeared,
month.
my lord. My lord, can you see the identical order?
4 weeks?
Your Lordship.
4 weeks. All right. এখানে না একটা লাইন একটু রেকর্ড করে দিন, এমনি যা থাকবে সবই থাকবে, শুধু ওটা না 4 weeks হবে, 3 months যেটা আছে এখানে একটা লিখবেন, একটা প্যারাগ্রাফ শুধু আর্জেন্সি।
এটারও তুলে রেখে দেবে, এটাও তোমার কাছে রাখবে। আর্জেন্সি কিছু থাকলে এটা তুলে রেখে।
The petitioner has specifically stated in paragraph 11 of this writ petition that the petitioner have successfully qualified and appeared for the interview for the post of constables in West Bengal Police 2024 on 7th of February 2026, and the final merit list is expected to be published any day. Full stop. The petitioner further states that he has also qualified CBT-1 for the highly competitive post of assistant loco pilot within bracket ALP under the Railway Recruitment Board within bracket RRB with CBT2 scheduled on 28th of July 2026. Full stop. Considering the urgency pleaded in this writ petition, this court feels that direction should be passed upon the appellate tribunal. Now, this court feels
Request,
that
Your
the
Lordship.
interest of justice would be subserved if the appellate tribunal is requested to dispose of the pending appeal within 4 weeks.
If Your Lordship could just indicate the district, it will be convenient for the tribunal. The district of the district, Your Lordship. It would be at the top.
Jalpaiguri.
But no, Your
District
Lordship, the
Jalpaiguri.
No, district is for that particular district where his electoral roll was there.
No, it has to be mentioned where in the order.
Your Lordship, Your
Jalpaiguri
Lordship.
district itself.
All
But
right.
my address is at Jalpaiguri district.
Then
so
it will be easier.
Then
Then
it
it will
will
be easier.
Easier, Your Lordship.
আচ্ছা আচ্ছা, তাহলে একটা জায়গা করে দিন। Mr. Bari, which paragraph you have stated with regard to where your electoral roll was there?
My lord.
The appeal document would
Moinaguri.
contain that.
Moinaguri SC
Yes.
Assembly Constituency.
Yes. My lord. Paragraph
Acha.
5.
Paragraph
5.
5, yes. No, this is your mother.
My lord, also my also have I.
Where is your? Mr. Bari, yours will be only expedited
Yes,
fast.
Your
within 4
Lordship,
weeks.
it-
Others
Yes,
are
then-
usual.
My lord,
Here you have paid for all
Usual.
or?
No, only for mine.
Only
for people.
Where is your? Please show me the, your. Which paragraph? Where is that? You have not stated.
The appeal document would have it.
So, Ms. Pandey, if I mention the appeal number, no, that will not do.
Or the epic number.
Appeal number is there.
Or the epic number,
My
sir.
lord, page
Your Lordship.
28, epic number is there. It's a Moinaguri Assistant Constituency. My lord, can you
Moinaguri
see?
Assembly.
Yes,
Yes,
part number 111, I have stated.
the petitioner,
Page 28.
the appeal before the appellate tribunal relates to Moinaguri within bracket SC Assembly Constituency, full stop. The appeal preferred by the petitioner is registered as appeal number in a paragraph 8 না বিরাট নম্বর আছে, এটা দেখে নিয়ে ভালোভাবে লিখে দেবেন, এটা একটা উপরে করে দেবেন, তারপরে যা আছে usual।
Your Lordship could specify with regard to the mother in usual course. There are two
20,
petitioners.
25,
No, in this
25 is the
petition,
mother.
it's No, in this petition
25 is the
itself, my
mother.
25?
Item number 25.
No,
No, your
25, I'm not.
lordship, in this, there are two petitioners, I believe.
Oh, two petitioners.
No.
One.
Two petitioners.
One petitioner.
No, only one
My
petitioner.
my apology.
No, only one thing in paragraph, the mother's particulars were mentioned. I thought there were two applicants.
Your
Here it's
lordship.
only the, yes.
Much.
Yes, next,
Obliged, ma'am.
18.
18, my lord.
Yes,
This is regarding, my lord, the disbursement of the family pension. The petitioner is the widow of the deceased, my lord.
yes.
The deceased died in harness, my lord. For that, he could not avail the return the benefit of the CPF amount. My lord, thereafter, my lord, widow
Yes.
apply before the authority, my lord. My lord, kindly
Yes.
see the loss sheet order, my lord.
Disposed of. Next,
Order number 19.
19.
19th, my lord, I am next circuit.
On the prayer of Mr. Ghosh, learned advocate for the petitioner, list this matter before the next available circuit bench. Yes.
20.
My lord, item number 20, there are certain dispute with the annexure, my lord. I'm praying for withdrawal the application petition.
To withdraw and to file afresh.
File afresh, my lord.
The learned
Grant.
advocate appearing for the petitioner submits that there are certain technical defects in this writ petition for which the petitioner prays for leave to withdraw and to withdraw this writ petition and file afresh on the self-same cause of action.
I'm grateful.
Full
Your
stop,
Lordship.
paragraph, in the light of the submissions made by the learned advocate for the petitioner, WPA number such and such stands dismissed as withdrawn with liberty to the petitioner to file afresh on the self-same cause of action. Next.
Number 21.
Your lordship, I am for the petitioner, your lordship. This is a SIR matter.
SIR.
Yes.
SIR. Usual order. Yes, next. Disposed of. Next.
22.
I am on behalf of the petitioner.
Yes.
Lordship, this matter is related to praying for the implementation of the mandatory direction against the state respondents for the disbursement of the amount which was been paid twice by the petitioner. My lord, the checkered history in the,
What is the amount?
my lord, it's respect to the 3 lakhs 3,78,000.
Where is that order? Direction to
Lordship, they are at page number 14.
14.
It was the earlier order, on the earlier proceeding, there was an order to pay the amount within 4 months, after which the appeal was been made. My lord, if my lord kindly,
Yes, Mr. So what do you say?
after which
Despite
subsequent,
our direction, why are you not refunding?
We have preferred an appeal.
that,
What we need to restore.
no, my lord, kindly come to at page number 116. They were given chance by the subsequent, by this honorable court on the subsequent proceeding to restore with a liberty that if it will not be restored within the period of 1 month and the stay will not be obtained, then the petitioner will be at the liberty to seek a mandatory
So
direction.
yes, there is no stay. So you refund. If you are entitled to, you can collect again. This cannot go on.
It's subsequently since 2021.
This
my lord.
cannot go on.
When the previous panel was there, the appeal wasn't diligently.
No, my lord,
But you cannot.
opportunity was been
This is
given.
an order. Please see in the event the order passed by the director is not stayed by the division bench within a month. This order was passed on 13th of January.
Yes, thereafter, no, thereafter one, my lord, kindly come to page number 117, my lord.
Yes,
Subsequent,
I am at 117. So that was passed in January. So now we are in August,
Let there be a direction for refund and then that refund will be.
subject to the decision in the appeal.
my lord, then it will, like along with the interest also, because at such a long period,
Sir, please get this. Then after that, there was no directions for interest. Ashun, the grievance of the petitioner is that in spite of repeated directions passed by this court, the respondent authorities have not refunded the money to the petitioner. First up, the learned advocate appearing for the petitioner draws the attention of the court to an order dated 13th of January 2026, passed by a coordinate bench in WPA 2644 of 2025 in support of such contention. So, Mr. Misro, learned Assistant Additional Advocate General, submits that against which an appeal is pending, Mr.
Yes, ma'am. Against the first writ order that was there.
Which order? Can you give me the date of the order? Is it 7th of March 2022?
Yes.
Submits that challenging an order dated 7th of March 2022 passed in WPS 621 of 2022. An appeal being
1094 of 2022.
1094 of 2022 has been preferred.
Which was dismissed for non-prosecution on 30th April 2022.
He submits that the said appeal was dismissed for non-prosecution on
30th day of April 2024.
30th of April 2024. He submits that steps have been taken for restoration of the said appeal.
No, we will take the step.
No,
Oh, you
step
have
will
not
be
yet
taken.
taken
No,
steps.
not, neither it was been restored, my lord.
Submits that steps are being taken. Steps are being the steps shall be taken. Steps shall be taken to file an application for restoration of the said appeal. So, stop. Be that as it may, this court finds that the coordinate bench, by an order dated 13th of January 2026, has specifically observed that in the event the order passed by the coordinate bench directing refund of money is not stayed by the Honorable Division Bench within a month, the petitioner will be at liberty to pray for mandatory directions upon the respondents for dispersal of the amount. Full stop. More than 6 months have elapsed since the passing of the order dated 13th of January 2026 in WPA number 2644 of 2025, and it is not in dispute that till date no steps have been taken to restore the aforesaid appeal, which stood dismissed for non-prosecution long time back. First paragraph, in view thereof.
It's
Not our fault, not even the last panel.
It's your fault, may not be Mr. Misro's fault. You are the state, Mr. Misro. State cannot be a different. State is one. First up, in view thereof, the who will refund?
respondent number 2, my lord.
Respondent number 2, Mr. Misro. The respondent number 2 is directed to refund. The respondent authorities. The respondent authorities are direct.
Not why the union has been made a party.
No, the union also has been made a party, but the specific direction has been respected in respondent number 2.
7, he's the adjudicating.
No, where was the direction? Please show me.
At page 1, at 14.
Director of Commercial Taxes.
Yes.
To take steps, because that was the initial order.
Yes.
No, but the adjudicating authority will refund it.
This was the direction I cannot modify. See page 17. This was the direction. I cannot modify that. By directing the Directorate of Commercial Taxes, Government of West Bengal, being the second respondent, to comply with the directions passed by the
second respondent that they have made, there will be no contempt will lie against that. It is in their favor that they go for respondent number 7. My suggestion.
But Mr. Misro, I cannot modify that. I cannot modify that. To comply with the directions passed by a coordinate bench on 7th of March 2022 in WPA 621 of 2022, um, positively within a period of uh, 3 weeks from the date of receipt of a server copy of this order, along with the photocopies of the order dated 7th of March 2022 passed in WPA 621 of 2022 and the order dated 13th of January 2026 passed in WPA number 2644 of 2025. So, step, it is however made clear that the payment and acceptance of the said amount shall be subject to the decision in the there's nothing pending. Nothing is pending.
It's at certain finality, my lord. My lord, it has certain, my lord, it has certain finality, my lord. This
There is
order
no appeal subject to a
subsequently,
decision.
my
I
lord,
cannot say.
that
Yeah,
cannot
last
be
line
done.
take it. Yes.
Grateful.
Yes.
Order number 23.
Look, 23
Yes.
is related to SIR matter. my lord.
SIR.
Yes.
SIR.
I'm for the petitioners.
All right, disposed of.
My lord, one indulgence, matter,
Much
both
obliged.
affidavit of service.
Affidavit service, yes, taken on record. Disposed of next. It is usual,
Grateful,
3 months charge. Yes, next.
24.
I beg to appeal for the
That's
petitioner,
fine.
Lordship.
I'm
This,
coming after 5 minutes.
Lordship.
Item number 24.
Lordship, I beg to appear for the petitioner, Lordship.
Yes.
Lordship, this is the matter regarding the general transfer or medical ground, Lordship. The petitioner made a prayer on in the year of 2021, Lordship, that is 4/12/2021, on the medical ground, Lordship. He was totally 50% disabled.
Why does the physical handicap person? Now, physical handicap person.
And Lordship, after that, the distance between his present school and the distance between the present school is 121 kilometer, Lordship. And I already obtained the no.
Why did you join?
Lordship, I
Knowing
already.
that you have joined.
Lordship, I already got the no objection certificate of the managing committee also, Lordship.
My lord, I am appearing on behalf of the.
Lordship, that time I do not.
10th of August.
My lord,
It has been submitted.
my lord, in this matter, my lord.
Lordship, already, Lordship, yesterday informed me to inform the school service commission, Lordship. I already informed the Mr. Sumit.
Communication.
Lordship, but the commissioner is the main answering respondent, Lordship.
What? Yes,
My lord,
to take
kindly turns to
instructions.
page 42 once. Kindly turns to page 42 once.
Yes.
My lord, subsequently, the petitioner made an application in the online portal.
Yes, Lordship, that was temporarily
And
under
his-
maintenance, Lordship.
My lord, the application is not under the medical ground. Rather, my lord, on the ground of physically handicapped.
Yes, now your application is not on the ground of medical ground. It's a physical handicap reason. And that was the reason on which you have got the appointment. Can it be a ground for transfer?
Let Lordship then let it consider in
Another
accordance
thing, my
with
lord,
law.
50% physical
How can it
disablement.
be considered?
My lord, 50%
Let the direction
physical
of the DM to consider in accordance
disablement
with
is
law.
not the ground for transfer.
Lordship,
My lord,
already I
in-
got the objection from the no objection certificate from the concern of.
Maybe that cannot be a ground because on that quota you have got an appointment. Now you want transfer on that ground. How can it be?
And
Should
don't
not have
provide-
accepted that appointment.
ও তো করে দিয়েছে নিজে নিজে।
Should not have accepted that appointment. It was difficult on your part to attend the duties. Should not have accepted that. Other persons could have joined there in that
But
post.
Lordship, now there is a vacancy in the nearby school, Lordship.
My
That
lord,
cannot
and
be a
legally,
ground.
my lord, 60% is the.
Lordship, I am only paying for the consideration, Lordship. Kindly consider because my father is 72 years old. That is also I mentioned in my petition, Lordship.
That is not the ground.
And
for
my wife
transfer.
is also in, Lordship.
The heard the learned advocate for the petitioner and the school service commission. The learned advocate appearing for the state submits that in the communication letter it has been mentioned that this matter will appear on 10th of August 2026. First he submits that he has not yet received instructions to stop list this matter before the next available certificate. Next.
Item number 25.
Yes.
25, I'm appealing for the petitioner, Lordship.
Yes.
My lord, what has happened here, the appellate order, in the appellate order, 3 adjournments sought. Out of which had been given, the other rejected. Now, the question is, in the appellate order, they have stated that they have given us 3 adjournments. Now, why this happened? Lordship will kindly straightway come to page number 78. And this is the first notice of personal hearing. Pursuant to filing of my appeal, this is the first notice. Page 78. Here, Lordship will see the date of personal hearing is given on 4/9/2024.
So where is the appellate order?
Lord, the appellate order is at page number 85. But Lordship, before going into that appellate order, Lordship kindly comes to page 78 once.
No, I will come to that. Please show me the appellate order.
Yes. Page 85, Lordship says the point of contention is at the bottom, the last paragraph of this appellate order, of the first page of the appellate order. That is 85. Page 85, bottom part. The personal hearing was issued. Personal hearing notice was issued to GST portal fixing date of the Subsequently, 3 reminders or adjournments were issued to the appellant fixing the date of hearing on the that the appellant or any authorized representative did not appear before the undersigned. Appellant again furnished reply through online to give another date of hearing. Kindly come to page 78. Page 78 is the initial notice calling me for hearing, fixing the date on 4/9/2024. Thereafter, at page 79, Lordship kindly see. My lord has got it. My lord has got it, my lord.
No, Mr. Bhattacharya, the appellate authority has disposed of your appeal on merits.
No,
You appeared before the appellate authority.
I did not. I could not. I had prayed for a time. But that was
You do not have a
granted.
right of adjournment. Mr. Bhattacharya, you do not have a right of adjournment.
True. I do not have a right for adjournment.
So,
But at the same time,
so you can challenge that.
My lord,
Mr.
the
Bhattacharya,
act
you
says-
challenge that by prefer an appeal.
My lord, the act says.
Challenge that, prefer an appeal before
My
the
lord, the
tribunal.
act
Yes,
says- the
because
act
now
says that three
your
adjournments to be
opportunity was
granted.
given.
My lord, three
Maybe.
adjournments to be granted. That is the act says. 107 subsection 9, Lordship kindly take.
That's not a matter of right. That's not a matter of right that you will be allowed 3 adjournments.
True, but
So
my
it's the
lord,
discretion of the authority whether to grant or not. Please challenge this on merit before the tribunal.
my lord, only one humble submission. The administrative discretion is not as latitudinally flat as the judicial discretion, my lord. Administrative
Maybe you
My lord,
challenge it on merits. You will be having an opportunity to consider to make your submissions before the appellate tribunal. All matters in this
But my lord, the
cannot
only-
be
only-
granted
no,
in this
not-
way.
not
Prefer an
all.
appeal.
Not all, my lord, but here there is. I had prayed. There was a complete process. I had uploaded the adjournment notice, and thereafter also they have not given me. Only
Maybe
one date could not have-
they are not bound to give. They are not
True, my
bound
lord,
to give.
true.
Please show me that you are entitled to 3 adjournments. They are bound to give.
Not bound. I'm not saying that. I'm only saying that.
That has been rejected. You prefer an appeal before the tribunal.
But on wrong,
You approach
wrong
the tribunal.
consideration. Not on wrong consideration. They were under
That
the
wrong
opinion that they have
consideration,
given 3
Mr.
adjournments.
Bhattacharya, all points will be left open before the tribunal. Raise all points before the tribunal.
Lordship will not take me amiss. Only one humble submission. Here, what they have stated that I have already given you 3 adjournments, I will not give you more. But actually, they have given me 2 adjournments. They had made a mistake.
All right, I will record that. I will record that they have only given 2, not 3, and I relegate you to the tribunal.
Yes.
Where is that provision for adjournment?
107 subsection 9, Lordship kindly. 107 subsection 9 proviso. The proviso to that. The appellate authority may, if sufficient cause is shown at any stage of hearing of an appeal, grant time to the parties.
Yes. So if sufficient cause is shown, so you do not have an absolute right of adjournment.
My lord, the
And proviso
is a cancer patient.
Proviso is
My lord,
the
the
outer
petitioner is
limit.
a cancer
Proviso
patient.
is the outer limit.
True.
Proviso is the outer limit. It's not that you are entitled to 3.
I am only on.
Court may not grant even 1.
Very fairly.
Yes.
But my only humble submission is that they were under the misconception that they had already given me 3. But it was not the case. They had given me 2.
Please show me that.
Yes,
show me that.
Yes. Lordship kindly takes page 78. 78, Lordship takes. This is the first hearing notice given to me. Date fixed on 4/9/2024. 79.
No, this is
This is the first
78 is the adjudicating authority.
No. Appellate authority.
78.
78. Annexure P8.
No, what is page 101?
101.
Yes.
Not sure. 101. There is no 101 in this.
দেখি তাহলে কি দিলেন অন্য ফাইল দিয়েছেন আই এম লুকিং এট 101
No, my lord. There is
ঠিক
no
ফাইল দিলেন
101.
নাকি
WPA number 1470, my lord.
Yes, this is 1465. Yes, there is 101 and except
My lord, 1470, not 1465.
1470. That is 29. This is 25. Mr. Bhattacharya, this is item number 25.
My lord, I tender my apology. This, my lord, in this matter, there is no scope of any interim order. The matter may be simply admitted. It's a Caesar matter, my lord. The goods are standing, pan masala, and there are contentious points on this. This matter can be just admitted, simply admitted, my lord. Because I think the other side would like to prefer opposition here. Completely factual.
Mr. Bhattacharya, this is an appellable order before the tribunal.
Here the question is the tribunal.
So this is also same.
No, this is a Caesar matter. This is a Caesar matter. Vehicle standing. Here the vehicle is standing, it's a Caesar matter. And
1465.
1465, yes.
So you are looking at 1465. Where is that 2 adjournments, 3 adjournments? Please show me that.
My lord, that is not here. That is not here. That was in 29.
No, Mr. Mishra is saying that is here.
No.
That is the problem.
No. This is, my lord, a Caesar matter, Wayside Caesar, where the goods have been seized, the vehicle is standing. And here, my lord, in nutshell, what has happened, I'll tell you, lordship. Here, there was a discrepancy.
Yes, sir, Mr. What do you say?
This can be, I think they should want to file opposition here.
But Mr. Bhattacharya, is it not an appellable order before the tribunal?
No, the only problem is I want to pay the money. But unfortunately, the department is not accepting my payment. My goods are lying stranded. I want to pay the money.
A vehicle was intercepted.
Yes.
The vehicle, lords, there were certain discrepancy that was found. What was the discrepancy, lords? 18 lakh pouches of Bahubali pan masala. The MRP was 3. That is the declaration that they made in a tax invoice. Now, when the actual interception was done and when the goods were seen, milords, it was taken into account that only 7 lakh 92 pouches of Bahubali pan masala was there with the MRP 3. The rest 1 lakh 8,000 pouches were with the MRP of ₹4 each packet. So therefore, there was a discrepancy.
True.
Then the second
True,
one
and
was
I wanted to pay it off.
Sir,
I wanted to pay it off. But
sir,
what
let me
they are
complete. Then we will see whether you
they
want to
will
pay it
take
off or not.
penalty and
The
tax
second
on
allegation
the
was that there was excess of 18 lakh 6,210 pouches, which were not accounted for in the tax invoice.
Not 18 lakh.
Their contention, my lords, today is
Mr. Bhattacharya, please allow Mr. Mishra to speak.
their contention today is that say for example, if a commodity is priced at ₹3 and not at ₹4, so there is a deficit only of ₹1. So I will pay the extra tax that is there only for that ₹1. That, my lords, is what they want to say. But our contention is that is not what the case is, because it will be decided upon the violation. The entire goods has been violated and was not under the valid cover. Not only that ₹1 margin would be there. For example, if somebody orders a pizza and if a small pizza comes instead of a large pizza, the consumer will always say that there was a deficiency in service, not that the small pizza turned into a large pizza. They are trying to put it that way.
No.
Therefore, the appellate authority said that no, that entire transaction has to be looked into, and not only that part of transaction which was in excess there.
No, only one thing, Mr. Bhattacharya says the entire amount which has been directed to be paid, he wants to pay off.
Not the entire amount. What I am suggesting.
Then, Mr. Bhattacharya, I was under the impression that
no, he want to pay only for the excess amount.
No.
My lord, there are two things.
Please prefer an appeal, Mr.
Appeal before the
Bhattacharya.
tribunal.
Please prefer an appeal before the tribunal. Make all prayers there for return.
Yes, the tribunal is operational and
yes.
functional up and about.
Tribunal is functional now.
No, Lordship will kindly appreciate. Here, the question is there is 18 lakhs of pouches which are accounted for. Only 6,212 pouches unaccounted. Now, my humble submission is
We'll give somebody a right that along with exempted good, they will also push in non-exempted good, and then they will pass. And they will say that only non-exempted would be taxed.
0.38%. So I am ready to pay the tax and penalty on that. Because 18 lakhs.
No, on the entire.
18
No,
lakhs.
Mr. Bhattacharya,
The transaction was doubtful.
if you want the matter to be kept pending here, but that should be without any interim order.
I do
That
not
much
want
is
an
clear.
interim order. My lord, I do not want an interim order.
But you have paid for interim order.
No, no.
You have paid for interim order at
My
prayer
lord
eye.
knows, my lord has way more wisdom, greater wisdom than me. Lordship knows why prayers are made. But here we should not, I mean, we should be very candid before this honorable court. There is no scope
Yes,
of interim order.
Mr. File your
The
affidavit.
discrepancy, my lords, there is a discrepancy in the invoices itself.
That is why
So the
I
entire
say it's a
transaction is-
factual matter.
I'm not stopping
dubious.
you. I'm not also passing any interim order.
Yes, my lords.
Yes.
Mr.
Or
Bhatt-
the-
Mr.
I'm
Bhattacharya,
even
Saying
they
I'm
could have
not
taken
praying
it
for
in the
interim order.
tribunal.
I'm just praying
They
for
could have
admission.
gone to the tribunal.
I'm keeping the mentality issue also open.
My lords.
Yes,
I'm also keeping the mentality issue open.
very well.
Mr. Misro Lanet, Assistant Additional Advocate General, raises an objection as to the maintainability of this writ petition in view of an alternative efficacious remedy available before the
GST Appellate Tribunal,
GST Appellate Tribunal under section
112.
of WBGST.
Both.
Under section 112 of WBGST/CGST Act 2017. Mr. Bhattacharya, learned advocate, appearing for the petitioner, submits that the petitioner is not pressing the
Interim order.
prayer
My lord
for
will not record
interim
that.
relief.
My lord will not record.
Yes,
Yes,
Mr.
no,
Bhattacharya,
you
that
said
has
so.
to be
Very
recorded.
well,
Otherwise,
very
we will take
very
the
well,
advantage
very
of it.
Very well.
That is why I asked you.
Very well.
That is why I asked you.
Very well. I'm agreeing.
Is not pressing the relief is not pressing the prayer for interim relief as prayed for in this writ petition. Full stop. Accordingly, no interim order is passed. Full stop. Let affidavit in opposition be filed.
For the CGST.
All right. Let affidavit in opposition to the writ petition be filed within
4 weeks.
4 weeks from date. Full stop. Reply thereto, comma, if any, be filed within
2 weeks.
2 weeks.
2 weeks.
Within 2 weeks thereafter. Full stop. Parties will be at liberty to mention this matter for enlistment under the hearing after the expiry of the period
My lord.
for exchange of affidavits. The point of mentality of this writ petition is kept open.
Great.
Decriminalized.
Yes, next.
At 26, I'm for the petition.
Yes.
My prayer for electricity has been refused, my lord.
Refused.
Yes.
Who are you?
My lord, I'm the occupier of the premises. My father,
What is your status of occupation?
and I'm the son of the recorded owner now.
Who is
Because my
opposing?
name is not recorded, that's why. Because I'm not the recorded owner, that's why it has been refused. Even the application has not been accepted. My if you have to comes to page 15.
Where is the order of disconnection?
My page 15 once, I made a representation requesting restoration. My lord. The connection was disconnected due to non-payment of bills, my lord.
No,
So
no, no. The connection was in the
Mother-
name of your father.
Yes, yes.
Father passed away.
Father passed away.
That cannot be restored in the
Yes.
name of a deceased
Mother, kindly-
person.
kindly come
You have
to
to
the-
apply afresh.
Kindly comes to the reply, madam. Page 16, madam. Page 16.
Yes.
They informed us that since it was disconnected, remained disconnected for more than 180 days, so the contract ends, you have to apply afresh.
Yes.
So accordingly, I made an application, which is at page 17, madam.
Yes.
They refused to accept my application. I wanted to pay the outstanding bills, but they said that since it is not in your name, where the property is not recorded in your name,
Where is that?
but that they have not. That's a no.
Yes, you are for the
For the
electricity.
WBSDCL, my lord, we have to take instruction from the department, my lord, so kindly take for next circuit, my lord.
Now, I'm willing to pay the outstanding amount.
You consider the application text pass a reasoned order on that application.
My lord, at least.
Application has to be disposed of.
But they have to receive the application. They have not received the application. And they have only provided me the bill where after adjustment, it amounts to 18,660. Page 23.
Mr. Paul, learned advocate, appearing for the petitioner, submits that the electricity that the licensing company has refused to accept the application for supply of electricity. Full stop. He submits that the connection, the electricity connection standing in the name of his deceased father has been disconnected. Full stop. He submits that the petitioner is ready and willing to pay off the outstanding dues, comma, if any. Full stop. He further submits that the petitioner is in occupation of the property in question. Full stop paragraph. The learned advocate appearing for the licensing company prays for an accommodation. Full stop. List this matter before the next available circuit bench. To enable the learned advocate for the licensing
But
company
temporary connection
to
in the meantime.
cannot be done.
Grateful.
Temporary connection, what remains to be decided at the final hearing, Mr. Bal.
They cannot deny me the connection
That's a different thing. Then it will be a permanent connection. Why temporary?
for the time being. Grateful.
Yes.
My lord, item 27, there are, my lord.
My lord, number 27, I put the state, my lord. They served the copy yesterday and listed date on
No, my lord.
10th August.
I'm praying for withdraw the application with the liberty to file a petition.
Why?
There are some certain problem with the annexure. my lord.
What is the problem with regard to the annexure? Please move this. Let me see what is the problem with the annexure. Yes.
Then my
Please
lord, make
move.
it a short answer because Shan Banerjee was supposed to appear virtually. Then I'll make a call to him and he will appear.
Please make a call. Pass over. What do you want?
Two work order is there, lordship.
All right. Please make a call. Pass over, please. Appear. Let me see. Yes, next.
28 is also not service has not completed yet. 28, item number 28, service.
Service, not necessary. Let me see what is this matter.
Then my lord,
What is the matter, please?
28, my lord, as per their letter, it is to be listed on the 10th of August, my lord.
This is, let me see. Yes, what is this matter? 10th of August, I will see if they are.
My lord,
answer
item
is
number
necessary.
28.
Yes. What is your prayer?
My lord, am I audible?
Yes. Yes, you are audible, visible of both. Yes, what is this? What are you praying?
My lord, work has been completed. My lord, payment has not been done for last many years. My lord, but
It's a money
service has
claim.
not been. Is my lord?
Yes, service I will take care. Money claim, our writ petition is maintainable.
My lord, I can apprise this court.
Money
my lord,
claim,
kindly take
our
it
writ
up to
petition is maintainable.
My lord, my lord, ABL corporation. My lord,
Yes.
if my lord, there is, my lord, if my lord, ABL corporation, I am covered by my lord. If the work order has been
Yes.
floated by the state authority, my lord, and they are
Yes.
duty bound to make payment. If there are,
Yes.
if also even to that extent, if there are some disputes there, herein, my lord, my cases, my lord, there are gallows of orders were passed by the coordinate bench. These are at the time of COVID emergency, my lord. Primary school has been repaired. All has been done. My lord, subsequently, my lord, payment has not been done. The
Where is the
coordinate
completion
bench
certificate?
almost.
Please show me where is the completion
My lord,
certificate.
my lord, in the work order itself, Jagadish Chetri, my lord, page
No,
number
where is
10.
the completion certificate?
My lord,
Yes.
my lord, page number 10, that is the, my lord, page number 10 is the work order.
Yes.
My
No,
lord,
work order
in-
is there. Completion
Yes, my lord.
certificate. When you have performed an order,
Yes,
there has to be a completion certificate. Please show me the completion certificate that you have satisfactorily completed the
My
work
lord,
under the work order.
my lord, the work has been completed, only they have signed the same in left bottom. Let them file a report in that case, my lord.
No.
And my
You have to take
representation is also
instructions.
there, my lord.
Presentations can be made 100 times, my lord. The presentation does not signify that work has been completed.
My lord, may I apprise one thing, my lord? My lord, let a report be called for. Otherwise, my lord, even after
No, why
passing
report
the
will be
order
called
in
for?
so many cases, my lord.
Why report will be called for? You have to first satisfy, first cross the first threshold. Nothing is there.
My lord, they have said
There's no
what-
document to show that you have completed.
My lord, in my work order itself, they have signed and said work completed. In left bottom
Where
part,
is
in
that?
all the matters they have done in same manner, my lord. My lord,
Where
in
is
the
that?
work
Where is
order
that?
itself,
Please
my
show me.
lord, page number 10, page number
Page
10,
10.
page number 10, my lord. Yes, my lord, that is work
No,
order, Jagadish Chetri.
Who has signed it? No seal,
No,
nothing.
page 10.
Page 10
is
page
your
18, page 18.
page 18.
1469, WPA number 1469. My lord is
Who has signed this? Who has signed this?
Yes, my lord, page number 18, my lord. My lord,
number 18.
my lord, the engineer, my lord, that was floated by the BDO. The tender was floated by the BDO, my lord. And my lord, by the engineer, my lord, the bill is on page number 19. My lord, the bill is there.
what bill?
My lord,
When
everything
you
has
have
been done,
completed
my
the work.
lord.
When you have completed the work.
My lord, my
When you have
instruction is
completed the work.
2022.
22
My lord,
when?
my instruction is 2022. My lord,
Yes.
that I
So
have
3
not
years have already
very
elapsed.
specific with the instruction.
So it's a time barred claim. It's a time barred
My
claim.
lord, I can apprise this court also, my lord, I can apprise this court
it's a
also on
time
that
barred
point, my
claim.
lord, that a welfare,
2020
my lord,
welfare state time barred claim.
my lord, may I? Is my lord, there are judgment, my lord, I can apprise, kindly give me 1 day accommodation in that
No, we
case, my
also
lord, I can
judgment.
apprise. That welfare
Within 3
state
years,
and a
if it is
model
not claimed,
employer,
then
my lord,
it is a stale claim.
All right, I'm
lord,
keeping
may
it
I? My
in
lord,
the next
my
circuit.
lord,
This is
may I?
basically a
My
fishing
lord,
exercise to get documents if those are available in the office of the authority. We are saddled with lot of these, my lord. But kindly take, I'll also
my
take
lord,
this.
if,
Yes,
my
the
lord,
learned
my lord,
advocate appearing for the respondent prays for time to take instructions to submit this matter before the next available circuit bench. Yes, next.
my lord, item,
My lord, I am asking for the petition.
No,
Yes.
no, 27.
27 is also similar.
No, 29. No,
29 is
27 is also same.
27 is also similar.
Same. Next circuit bench. Yes, next.
29. 29,
29,
for the
yes.
petitioner, yes. My lord, this is the matter that I was pleading.
Granted, you want adjournment.
Oh,
Adjournment, yes. This is the matter of that adjournment. Lordship kindly takes.
this
page
is
78.
adjournment.
Yes, yes.
Yes. Where is the adjournment?
Yes, page 78, Lordship kindly takes. Page 78 is the first notice for the appellate proceeding. This is the first notice if Lordship has got it at annexure P8. So after this, I had preferred an adjournment letter. That is in the next page, page 79. This is my first prayer. Page 79.
Page 79 is the first pair. It was
First
allowed
pair.
at page 80.
Yes.
81 is the second pair, allowed at 82. Then it means 84 is the third prayer.
No.
And when it was not allowed,
that is where I
they
am.
say-
That is where I am. Lordship kindly takes page 82. Page 82 is an adjournment which is given on my pretext. Page 83 is given suo moto. Page 83 I had not prayed for. On
Maybe.
19th of December, I was there in the office.
Authority was not there.
But they had given a suo moto adjournment. I could have been there on 19th. But there were certain difficulties on the part of the authority. So they made a suo moto adjournment. And by virtue of that suo moto adjournment, my lord will kindly appreciate he's a cancer patient. He's a cancer patient. He stays with his brother. He has to make to and fro visit to Bombay with his brother. And that is why all these dates he could not appear. And
where is your application for adjournment?
my lord,
Where is your application for adjournment?
Page 84. Page 84. This is my application for adjournment, which was rejected. 30th day hearing.
As you are busy, as you are
that is given
busy
by
in
the
another
advocate.
matter.
That was
cannot
given
be
by
a
the
ground.
advocate. That was given by the advocate, Lordship. Lordship, see,
Yes,
I
so
cannot
that
improve
cannot be a ground.
my lord, I cannot improve. No, what they have written in their order is, we have already given you 3, we cannot give you more. Now, even the authority knew that this person was suffering from cancer. And that is why, my lord, Lordship knows. I cannot improve whatever is written in the adjournment letter.
Where is that?
Huh? How will the authority?
No, Mr. Bhattacharya. Same ground. The advocate is very busy advocate. Mr. Bhattacharya. Advocate is very busy advocate. On the next day also he will not be able to appear.
No, it is not.
On the next day he will also
advocate's
not be able to
fault.
appear.
My lord, let me.
Yes, cannot.
My lord, the advocate's fault was.
You prefer an appeal?
My lord,
We'll fight it out on merits.
my lord, the only problem.
Because
is
the tribunal also can adjudicate on facts.
person is a
Please fight it
cancer
on
patient.
merits.
Lordship, I will with humble, all my humility.
That's
Mr.
not the
Mishra.
ground taken. Mr. Bhattacharya, that's not the
No,
ground
I
taken.
have taken the ground in the writ petition, my lord. I have taken the ground in the writ
That's
petition.
neither here. No, Mr. Bhattacharya, you cannot take a different ground in the writ petition because I have to consider what was there before the authorities.
My lord, my only
Yes.
humble
So
submission
on
is
the
this.
basis of the materials
My lord,
that
my
were
only humble submission is this. The person is a cancer patient. My lord, the state will lose nothing in giving one opportunity of being heard. Even my learned friend Mr. Mishra will be at one with me here. The state will not lose anything. And he is a cancer patient. My lord can pass a line, add a line that this will not be treated as a precedence. Lordship, this is something that I request of the personal accord because
Yes, for preferring an appeal before the GST tribunal, how much amount he has to secure?
No,
Yes,
no,
please
that-
deposit 10%.
Yes, I will.
That will be kept as
I will,
security.
my lord. I will.
Mr. What do you say?
It is
If
for
the deposit 10%,
the time, my lord, the time.
here
He's a cancer patient. Time is a very, very important factor here. Let him
What do you
deposit 10%. But otherwise, because 107 appeal.
Now, what do you say? 10%? What do you say? 10% you are all it.
Grateful.
The Mr. Mishra, once we have said this application under Article 226 of the Constitution of India is directed against an appellate order dated June 30, 2025, passed by the second respondent. First up, Mr. Bhattacharya, learned advocate appearing for the petitioner, submits that though the statute prohibits more than 3 adjournments, the petitioner only paid for 2 adjournments. Submits that the statute prohibits more than 3 adjournments, and the petitioner has only sought for 2 adjournments. Full stop. He further submits that the petitioner is suffering from a terminal disease and an opportunity be given to the to represent his case before the appellate authority, as the order passed by the appellate authority was an ex parte order. Full stop. As the order was passed by the appellate, be given an opportunity to represent his case. Yes, full stop. And an opportunity of hearing be provided. Full stop. Mr. Mishra, learned assistant additional. Mr. Mishra, learned assistant additional advocate general, submits that adjournment is not a matter of right, and the authority and an adjournment can be, and the prayer for adjournment can be allowed only upon being satisfied that sufficient cause has been shown. Full stop.
And the authorities must give 3 opportunities.
He further submits that the statute does not
There is an outer limit.
submits that the statute submits that the the appellate authority is not bound to give 3 adjournments at the merely on the basis of an adjournment sought for by the by a party. First up, taking into consideration the present physical condition of the petitioner as submitted by, you have stated that in the writ petition.
Yes.
Mr.
I
Is
will-
that?
Yes, I'll show. Hello.
Which paragraph?
My lord, I'm stating
Paragraph 7,
para 7, my lord.
page 6.
Page
6.
6.
Yes.
কি বললাম? Now, as specifically stated in paragraph Roman 7. Paragraph Roman 7. Roman 7 is the continuation of which 2:7. 2
Roman
within
7.
bracket 7. This court is inclined to grant a last opportunity to the petitioner to appear before the appellate authority and contest the appeal. First up paragraph.
Finding that 3 adjournments is a matter of right, because this will be taken as a precedent.
First up paragraph. What is that section?
107, subsection 9.
Section 107 within bracket 9 of the CGST/WBGST Act 2017 states that the appellate authority may, if sufficient cause is shown at any stage of hearing of an appeal, grant time to the parties or any of them and adjourn the hearing of the appeal for reasons to be recorded in writing. Proviso thereto states that no such adjournment shall be granted more than 3 times to a party during hearing of the appeal. Full stop. Paragraph. Section 107 within bracket 13 of the WBGST/CGST Act 2017 states that the appellate authority shall, where it is possible to do so, hear and decide every appeal within a period of 1 year from the date on which it is filed. Thus, this court finds that the statute prescribes a time frame for expeditious disposal of an appeal presented before the appellate authority. Full stop. This court is not inclined to accept the contention of Mr. Bhattacharjee, learned advocate for the petitioner, that a litigant has a right of 3 adjournments during 3 adjournments during hearing of the appeal. First up, the expression sufficient cause used in subsection 9 of section 107 and the requirement to record reasons in writing for granting an adjournment would imply that adjournment is not a matter of right and can be granted by the appellate authority if sufficient cause is shown at any stage of hearing of the appeal. Full stop. ঠিক আছে? এইটা মাঝখানে দিয়ে দেবেন, তারপরে না যেখানটা বলছিলাম না, taking note of the physical condition, this court is inclined to grant a lost opportunity to the petitioner to represent his case before the appellate authority. Full stop, paragraph, accordingly, the order,
Terminal disease that in view of the terminal disease.
yes, that I have recorded, in view of the terminal disease. I've stated that, full stop, it is however made clear, no, it is however, full stop, in view, thereof, the order of the appellate authority dated
36/2025, June 30, 2025.
June 30, 2025, passed by the second respondent. তাহলে appellate authority লিখতে হবে না, passed by the second respondent is set aside. Full stop. The appeal, there's any number of the appeal?
No.
Where is
This is
that?
a huge number, my lord. At the top.
The appeal.
AD
The appeal,
190. Yes.
the appeal is, the appeal stands restored to the file of the
Remanded,
appellate
my lord.
authority.
My lord, remanded.
Stop. The appellate authority is directed to fix a date of hearing and after serving, please give a date, suggest a date. Yes, Mr. Bhattacharya, which date will be convenient?
Within 7 days.
Please suggest a date.
Within 7 days, let them issue me a notice according to their convenience. I will go.
No further notice. No further
Acha.
notice from here. Date, time will be fixed. Please
Next,
give me a date.
Monday, next to Monday week. Monday week will be fine, my lord.
So 10th
10th.
of August.
Yes, 10th of August.
What time? What time? The
11:30.
11. Not 11:30, 11.
11:30, the officer comes, my lord. All the officers, they come at 11:30. That's why.
One day he will come at 11. He will say, ask me.
Very well. I have no qualm. I can even go at 10.
What is the impression, Mr. Mishra? Your officers come at 11:30.
Go by what he said.
No, I am asking.
No, they have field duties as
No.
well. My lord. No,
I'm
my
not
lord.
saying
Even-
about
even
you.
They have field duties.
Your
They have-
officers, that is.
That is his confidential, unverified.
No. The officers come at 11:30 because they have field duties as well, my lord. Lordship,
One day
it
he come at
not-
11.
They have.
All
field
right,
duties
let it be at 12 করে দিন। At 12 করে দিন, 10th of August, এটা কি বললাম? কি বলে শুরু করলাম? না করে করুন। Mr. Mishra, learned Assistant Additional Advocate General submits that a date and time of hearing be fixed by this court in order to avoid all future complications. Full stop. Mr. Bhattacharya, learned advocate appearing for the petitioner, suggested that the hearing may be fixed on 10th of August 2026 at or about 12 noon. Full stop. Such submission is accepted by Mr. Mishra. Full stop. Paragraph. In the light of the submissions made by the learned advocates for the respective parties, WPA number such and such stands disposed of by directing the petitioner or his authorized representative to appear before the appellate authority, that is the respondent number 2, on 10th of August 2026 at or about 12 noon. Full stop. The second respondent is directed to conduct a hearing to take up the hearing of the appeal on the date and time mentioned herein before, and make an endeavor to conclude the same on that date. Full stop. If for any reason whatsoever the hearing cannot be concluded on that date, a short date of hearing shall be fixed, and the
on that
and the
application will not
appellate
end.
authority shall dispose of the appeal expeditiously. Full stop. It is however made clear that the appellate authority shall be free to reject any prayer for further adjournment at the instance of the petitioner. Full stop. Yes, Mr. Bhattacharya, anything more?
My lord, only one thing, the appeal cannot be completed in one day. It will take at least 2-3 hearings because they will have.
That is why I said,
Yes.
Mr. Bhattacharya, that is what I said. If it is cannot be concluded on that, short dates will be fixed. No
Lordship-
adjournment.
No, no,
Short
Lordship-
date
Lordship
within
will
bracket
get-
S করে দিন।
Lordship
Short
will-
date within bracket S. At a করে দিন, since the date and time of hearing has been fixed by this court at the suggestion of the learned advocate for the petitioner and in the presence of the learned advocates for the respective parties, there would not be any necessity to serve any notice of hearing to the petitioner.
Yes. Grateful, my lord. Grateful. Grateful.
CGST also heard the learned advocate. Yes, next.
My lord, item number 30 is also same as item number 21. 28.
Next circuit.
28.
Next. Yes, next.
31, Lordship, I am appearing for the petitioner, my lord.
My lord, I am
seeking,
appearing for
the
my lord, the
assistant
respondent
primary
board.
teacher, my lord. I am seeking transfer of this teacher, my lord, from Kujbihar DPSC to Paschim Midnapur DPSC, my lord, on the ground of medical issues, lordship.
So board
My lord,
will
I am
consider.
appearing for the, my lord, I am appearing for the board. My lord, secretary of the board will consider.
All right. Secretary of the board.
My lord, your lordship has already passed the order. Should I change it, my lord? The necessary changes are made, or
You have the orders.
I will change.
All right.
Lordship.
Disposed of. Secretary of the board to consider.
Yes.
Yes,
My lord, I am
next.
appearing for the board.
Yes, Mr. Bishas.
Yes, my lord, I am appearing for the board.
You are not visible.
My lord, I cannot, my lord, on the video because of the network problem, my lord.
All right. All right.
Grateful, my lord. Grateful.
Mr.
my lord.
Atul Bishas for the board. Mr. Atul Bishas for the board.
Grateful, my lord.
Yes.
32, my lord, this is also same inter-district transfer application.
My lord, I am
This is also
appearing for
same.
the board. Yes, my lord, I am appearing for the board.
Yes. Board will consider.
Yes,
my lord,
secretary,
board
my
Yes,
lord.
disposed of. Yes, next.
Grateful.
My lord, I am for the petitioner. This is a SR matter.
SIR disposed of.
Much
Next.
obliged.
34, your lordship, I'm appearing on behalf of the petitioner here. It is intra-district transfer, your lordship.
Yes. Board will consider.
No, the DPSC Jalpaiguri.
Oh, yes. DPSC. You have a copy of the order.
I would correct, I would do the
Please give.
necessary
Yes, DPSC.
DPSC and I would.
Yes. DPSC to consider. Yes, next. Every service taken on record. Yes, next. 35, who is appearing? দেখি কি আছে None appears for the petitioner at the time of call. No accommodation has been sought for either for the ends of justice. List this matter before the next available second page. Next.
36, your lordship, this is interest on gratuity matter, your lordship. The PPO was issued on
Do you have an order?
interest on gratuity. I can get that.
Yes, disposed of. Please give it.
Yes, absolutely,
Yes.
your lordship. This is the affidavit of service that might.
Every service taken on record. Yes, when you will give it?
After lunch, your lordship. This one I am not carrying, your lordship.
All right,
So
yes. Next. Thirty-seven, yes, who is appearing?
Cancellation of GST registration. Cancellation of GST registration.
Cancellation of GST registration. Yes, Mr.
Lord, I have intimated Mr. Agarwal to appear in this.
You have to deposit, file returns, deposit late payment charges. you have any order
Yes,
with
sir.
you?
This order also. My lord, I am.
On the prayer of the learned advocate for the on the prayer of the learned advocate for the petition, leave is granted to the learned advocate on record of the petition to amend the cost title of the writ petition here and now, comma, here and now, full stop. ঠিক আছে, cancellation of registration, GST registration.
This order passed.
Yes, please give it. You have to deposit within that. You have to open the portal.
2 weeks.
Regularization, Mr. Agarwal, learned advocate, না এটা একটা অন্যরকম ভাবে করুন, none appears for the petitioner at the none appears for the CGST authorities at the time of call. First, Mr. Agarwal, learned advocate who usually appears for the CGST authority is requested to appear in this matter. Let the appointment of Mr. Agarwal along with a junior of his choice be regularized by the concerned authority. A copy of the writ petition has been served upon Mr. Agarwal. তারপরে হার্ড মিস্টার আগারওয়াল যখন করো হার্ড নেক্সট Yes.
38, I am appearing on behalf of the petitioner, your lordship. This matter also pertains to the order of transfer dated 13th of March 2020.
I'll need instructions. It is
What happened?
my lord, on 10th
Rejected.
10th of August, my lord, it is supposed to come back.
It was, the order of transfer was passed by the chairman, but subsequently was not allowed to join.
Yes,
your
Mr.
lordship.
We
Bhattaji,
have to take instruction. I'll tell your lordship why. This I don't have instruction because as per the covering
No,
letter.
there are several other matters.
Yes, and my lord, to be very candid, my lord, after the DI took charge, a Pandora's box has opened, my lord. A lot of these transfers are completely against the rules. Now, what has fallen from your lordship, my lord, that whether the DI can sit in appeal and his own order, as matters are pending before your lordship, I'll try to satisfy your lordship on that point. But I don't know about this case, but that case, my lord, the procedure were completely given go by.
What do you want now?
In those cases, my lords, we would be praying to file affidavits.
Your lordship, in that regard, those matters are also running in the list. I mentioned it in the morning, your lordship. Kindly stay the transfer or changes of PTR in the school where the present petitioner is.
No, that
and-
cannot be done. Rationalization process has started, my lord.
Your lordship,
In lot of cases, my lord, transfer has been given to a surplus school. In the case where I am appearing,
No, she is now,
in this I don't have instructions, my lord. This is, my lord, scheduled to appear before your lordship as per the covering letter on 10th of August.
this has to be.
Kindly
No,
consider-
I have to take instructions, my lord.
Mr. Bhattaji, learned additional government Peter submits that in the communication letter, it has been mentioned that this matter is scheduled to appear on 10th of August 2026. To stop, accordingly list this matter on 10th of August 2026 before the next available second bench. Yes, next.
39, I'm appearing on behalf of the petitioner, your lordship. This is for general transfer, intra-district general transfer, your lordship. I
Item
think the
number
particulars
38.
All right. Disposed of. Next. Yes, next. Please give it, after recess, madam, please give those.
I beg to approve the petitioner lordship in this matter.
My lord, is scheduled to appear on 10th of August.
Lordship, kindly, this is only for consider my representation. Lordship,
Why
this
have
is
you
the
given the date of 10th of August then?
Lordship, I have to cut because the from the LR office, there is a direction to
48 hours, my lord, it is.
Lordship, only for representation consider. Lordship, your order, I am relying your judgment, Lordship, in this matter.
Next available second bench, 10th of August, that's same. Next.
Yes.
41.
41, lordship, I'm for the petitioner. This is the matter, my lord, where the Jila Parishad has sent all the documents.
Yes.
Yes, lordship, I'm very candid submitting, lordship, the department has lost the document, lordship.
Has lost the document.
Yes, lordship.
So I direct the Jila Parishad
Yes,
to
yes,
again
One second,
saying that.
1 second.
Otherwise, my lord, I will be the sufferer,
Yes,
lordship.
The petitioners are presently
My lord, one petitioner.
one
lordship.
petitioner.
Yes, your lordship.
The petitioner is presently performing his duties as a Group D employee under the Kuch Bihar Jila Parishad. Sister. The petitioner claims to belong to the backward class community having the requisite qualification for appointment to the post of Group D. First up, the petitioner states that on 4th of March 2010, a meeting was held under the Shobadipati Kuch Bihar Jila Parishad to approve the services of the casual workers working under the Kuch Bihar Jila Parishad from their respective dates of joining. First up, the petitioner claims that his name is also appearing in the list of casual workers, and a decision was taken to approve the petitioner in Group D post. First up, the learned advocate appearing for the petitioner submits that the petitioner has sought for a direction upon the Special Secretary, Department of Panchayat and Rural Development, Government of West Bengal, to provide them the benefit in the light of the memorandum dated September 16, 2011. So the learned advocate appearing for the petitioner submits that in spite of the fact that the Kuch Bihar Jila Parishad has forwarded necessary papers and documents to the concerned authority, the benefits in terms of the memorandum dated September 16, 2011 has not been disbursed in favor of the petitioner till date. First up, when this matter was taken up for hearing on 28th of July 2026, Ms. Singh, learned junior government advocate, prayed for an accommodation to revert back with necessary instructions. First up, today when this matter is taken up for hearing, Ms. Singh submits that the submits, on instructions, the documents forwarded, that though it appears from the documents annexed to the writ petition that the relevant materials was forwarded to the Secretary, Department of Panchayat and Rural Development, but the said papers could not be located in the said department. First up, he submits that a direction be passed upon the Jila Parishad to forward the requisite papers and documents to the Secretary, Department of Panchayat and Rural Development, and if such documents is forwarded, the said respondent authority shall consider the same and take a decision within the time limit that may be fixed by this court. First up, paragraph, in the light of the submissions made by the learned advocates for the respective parties, this court is of the considered view that the interest of justice would be subserved if the additional executive officer, Kuch Bihar Jila Parishad, being the fifth respondent, is directed to forward the necessary papers to the Secretary, Department of Panchayat and Rural Development within a specified time frame. First up, paragraph, accordingly, WPA number such and such stands disposed of with the following directions. Number one, the additional executive officer, Kuch Bihar Jila Parishad, being the fifth respondent, is directed to forward the papers forward the necessary papers and documents for getting the benefits under the memo dated 16th of
February, Lord. 16th
16th of-
September
16th of September 2011.
Yes, your Lord.
16th of September 2011 to the Secretary, Department of Panchayat and Rural Development, being the to whom it will be sent? Special Secretary.
Yes, yes, yes.
Special Secretary?
Yes, Lordship.
To the Special Secretary Koredin, being the, no, earlier it was sent to the Assistant Secretary.
My lord, my lord, in all secretary, my lord, it has been sent to the assistant secretary, deputy secretary, special secretary. And I
To
have
the-
made all of them.
To the Special Secretary, Assistant Secretary, to the Assistant Secretary, Department of Panchayat and Rural Development, West Bengal, being the second respondent. Time policy, as expeditiously as possible, but positively within a period of 3 weeks, within a period of 4 weeks from the receipt of a server copy of this order. Full stop. The Assistant Secretary, Department of Panchayat and Rural Development, being the second respondent, immediately upon receipt of the papers from the fifth respondent, the Assistant Secretary, Department of Panchayat and Rural Development, being the second respondent, shall take a decision, shall consider the same and take a decision by passing a reasoned order as expeditiously as possible, but positively within a period of 8 weeks from the receipt of the necessary documents. So next, if the Assistant Secretary is of the opinion that that such authority is not competent to take a decision on the issue, the papers and documents shall be immediately forwarded to the competent authority within a week from the receipt of the papers from the fifth respondent, and in such event, the competent authority shall take a decision with regard to the proposal forwarded by the Jila Parishad within the time limit mentioned herein. If you find within 1 week, you have to send papers. If it does not fall within your jurisdiction. Yes, call the other matters.
On item number 42, just two more things, my lords, I wanted to point out. One, my lord,
42,
says,
Mr. Biswa, come back at 2 p.m. 2 p.m. Yes.
Your Lordship, 111.
SIR.
111 to 120.
2 p.m. lucky. 2 p.m. matters. Yes, all the other matters.
111, Your Lordship.
Item number 111.
Yes.
My lord, item number 111 and 112, I'm for the petition.
SIR. 111 to 128 disposed of.
Your
Same order.
Lordship. Your Lordship.
Yes.
111 and 12.
Please give your appearances. So,
Appearance to be.
13, 113.
I mean,
One indulgence, my lord. Yesterday on my prayer, my lord was pleased to direct listing of my matter.
Yes.
Considering urgency, but that is 152, 153.
It's
My lord,
difficult
kindly
because
take at any time today.
it's difficult because today one matter has been, two matters have been fixed at 2 p.m. Because thereafter, because it will take some time. Let me see how far I can proceed.
They are not getting salary, my lord.
Last
They're
two-
penniless actually.
I appreciate that, but let me see how far I can proceed.
My lord, 152, 153, my lord.
Yes.
One indulgence. Because item 56, because yesterday all of that taken up as a surface matter. Because the ban is given in the instruction. Kindly any.
Let me see how far I can proceed. Yes. Yes.
Humbly request.
Mute হয়ে আছে।
May I humbly request?
বইটা কোথায়? মোটা বইটা।
Am I audible, my lord? I'm not sure.
Yes, yes, Mr.
Have a look at couple of the.
My lords, may I request?
Yesterday, my lords, we were looking at.
I've taken your book.
Yesterday, my lords, we were looking at 17.3.
17.
Section 17.3.
Yes.
And in respect of 17.3, my lords, we said that in case of any casual vacancy in the office of the chairman for death, resignation, removal, or otherwise, the board of councillors are in accordance with the procedure as may be prescribed one of the council of the vacancy. Now, I was specifically not emphasizing upon the word prescribed because whenever a statute says that something has to be prescribed, it is there in the text. But then, lords, the three have to be read all together once again for the reason because, lords, it applies only in case there is a casual vacancy in the office of the chairman.
Constitution.
Yes, we will begin with the constitution, lord, for a moment.
No, I will.
If I can have my lordship for a moment because 243U was referred to.
No, you can place this, then you can go. I wanted because I knew that you will be placing constitution. That is why I asked my officers to give me the constitution.
So if I can have my lords for a moment on 17.3 once again.
Yes.
What I was trying to impress upon my lordship was that this applies only when there is a vacancy in the nature of a casual vacancy in the office of the chairman. In this case, Lord, 17.3, the procedure prescribed, Lord, yesterday we were looking into 6.2A. 6.2A is the procedure, Lord, that specifically applies only in case of 17.3. Generally, what happens, I will put it in an omnibus manner, Lord, then it will be a little bit more clear. What happens is there is the election of the councillors that happens. By way of the election, Lord, the councillors, they are elected. Now, these councillors, they uniformly form a board of the councillor. Now, there is a first meeting that happens because initially there is nobody to convene the meeting. Therefore, what happens is that there is a first meeting that happens. That first meeting, my lords, happens by way of an officer, and that officer, my lords, nominates a president, and the president holds the first. Now, once the first meeting is there, and once, my lords, the appointment or election of the chairman is done, thereafter, my lords, what happens is that the baby, my lords, gets separated from the umbilical cord. So now it has to survive on its own. There is no officer that's going, there is no control of the state that is happening there. It is, everything has to evolve upon its own. Therefore, after the first meeting, lords, every subsequent meeting that would happen, there is no provision for any officer to be intervened in those cases. What happens, lords, is that the chairman has to hold the meeting. That, lords, will find, for my satisfaction, if I can have for a moment on section 16 first. Section 16 first. Section 16, my lordship says, and then I will come when the vice chairman can also hold the meeting. Section 16 is not related to the powers and functions of the chairman. 16.1, my lordship says the chairman shall be the executive.
Section 16 of the Act.
Of the Act. And then, lords, I will also go to the constitution and try to, lords, decipher from there as to how the act must fall within the four corners of the constitutional provisions that are there. Section 16, lords.
Mr. Mishra, how much time we will be taking?
Less than Mr. Ghosh.
10 minutes. 10 minutes.
I
Yes,
will,
section 16.
but I will take 12, 10, 12.
Oh, he's taking more time than you.
You will be again replying.
On the point of law, not on facts. Facts have already been placed.
Yes.
Section 16 refers to the powers and functions of the chairman. The chairman shall be the executive head of the municipality, and the municipal administration shall be under the control, and he shall exercise such power and functions as conferred on him by office. 2 minutes is important. The chairman shall preside over the meetings of the chairman in council as well as the board of the councillors. So it is the chairman who has to preside over the meeting of the board of the councillors. Now, just in case if the chairman is not available for any reason, then in that case, not the vice chairman has to do so. And that may not be find is provided in section 15, in section 21. No, it is. Section 19. The vice chairman, in the absence of the chairman, presides over the meeting of the chairman in council as well as the board of council.
Section 19.
19. That is given in 9. So from the conjoint reading rules of section 16 with section 19, there are two different authorities who can hold the meeting for the board of councillors. Now, I am not repeating the facts. My lordship knows what the fact is. The vice chancellor, he resigned. The chairman, he accepted the resignation of the vice chairman, and thereafter the chairman also resigned. Now, if I can have my lordship for a moment on 17.
Please give me
It
one
was
minute.
referred to yesterday also. 17.3. So the procedure minutes in case of 16 and 19 is different. The procedure in case of 17 is different. 17.3, when it says that in case of any casual vacancy in the office of the chairman caused by death, resignation, removal, or otherwise, the board of councillors shall, in accordance with the subconstitutional shall elect one of the councillors to fill up the vacancy, and also not 17.4. In case of casual vacancies in the offices of both the chairman and the vice chairman caused by death, resignation, removal, or otherwise, the state government may appoint by name one of the councillors to be the chairman, who shall hold office until a chairman elected under the provisions of subsection 3 enters upon the office. Provided the chairman appointed under this subsection can hold meeting of the board of council within 30 days for the date of taking over the change, for the date of taking over the charge for the purpose of election of the new chairman under subsection 3 in such manner as may be prescribed. So, my lord, what is provided here, my lord, says that either the chairman has to hold the meeting or the vice chairman has to hold the meeting in case of the death of the chairman. Now, my lord, for a moment on 6.2a, rule once again. Or before that, 17.3. When 17.3 says that the board shall elect, 17.3 does not provide as to who will convene the meeting.
Seventeen three? No, I could not follow. 17.3, what is the submission? No, you said what is the last?
17.3, I am saying, lordship, is that in case of a 17.3, because there is a casual vacancy only in the office of the chairman, therefore the vice chairman had to do that. And the vice chairman is also there, not there. Therefore, 17.3 will not apply.
17.3 will not apply.
And if 17.3 does not apply, then 6.2a also will not apply. Because the procedure for 73 is prescribed in 6.2a. And I'm coming to that.
Yes.
Before that, if I can also.
All right. So according to you, section, since both chairman and vice chairman are not there, 17.3 will not apply.
Will not apply. Then, my lordship, if I can have for a moment on rule 13.1.
Rule
13.1. And then from 13.1, we will go to 6.2a. to understand the scheme of the act. Rule 13(1), my lordship says that the chairman or vice chairman shall preside upon the meeting. This rule 13(1) my lordship is applicable in case of 17(3). Now here in both the offices are vacant. Neither the chairman is there nor the vice chairman is there. Now, my lords, you need to read rule 6(2)(a). In the beginning of rule 6(2)(a), what is provided, my lordship, is that the chairman has to convene the meeting for the acceptance of his resignation. Because the act says that if the chairman resigns, then in that case there has to be a ratification of his resignation that has to happen. And it is for the purpose of ratification of the resignation that the meeting has to be called. In my case, the chairman was asked to conduct a meeting. He said that he will not do it. That is there in the facts. I have given the documents that is substantiated from there. He said that he is not going to convene any meeting.
So where is that?
Yes. In the documents that I have given to my lordship.
Yes.
In that series of documents, the municipal officer tried to make a I am on the lord's.
Yes, executive officer writes to chairman to convene a meeting on 22nd of June. Then where is that chairman's?
This not supposed to be a letter by the executive officer to
Yes.
the magistrate, 4th page. It is dated 27th of June 2026.
No, 22nd of June.
Yes, my lord.
The executive officer writes to the chairman to convene a meeting.
Yes.
22nd of June.
Yes.
No, you said that the chairman refused. Where is that?
Yes. Next page.
No, next page is executive officer to the.
Executive officer is writing the DM. What he is saying in the
Yes.
in the 4th paragraph, prima facie, as per the verbal declaration of the chairman, he is not willing to convene any meeting regarding his resignation.
Oh, this is the
So the
executive officer's
Yes.
statement. He says that he had a verbal.
Communication with the chairman.
Yes.
And the chairman is not willing to convene any meeting. So the ratification of his resignation is still due. That ratification couldn't be done. It had to be ratified by the meeting convened of the board of the councillors. That didn't happen in this case.
What is the effect of that?
The effect of that note is not given in the act.
No. So what will be the effect? If a
just
statute
clarify.
prescribes a ratification, because usually resignation has to be accepted in ordinary cases, in all cases.
In this case, maybe by the board of the councillors.
Yes, so resignation has to be accepted by an authority. So merely because one person sends a resignation, it does not operate from that date. So it operates upon acceptance. So here in this case is upon ratification. Then what would be the effect of this? Non-ratification?
It is pending state of suspended animation. It is in the state of suspended
So the
animation.
chairman has not resigned.
So the
Resign-
chairman has not resigned.
Yes.
Legally speaking, that's not the situation.
So we
Not-
cannot
chairman
now
has
say,
not resigned.
now,
A meeting
now,
would have been called by the vice chairman.
yes,
The
now,
vice chairman is not there.
yes, now it cannot be said that the chairman has resigned. He has only expressed his
He has
intention,
tendered his resignation.
expressed his intention to resign, but resignation is yet to be accepted.
Is yet to be accepted. And that has to be ratified by the board of councillor by a meeting called by the vice chairman. Unless the vice chairman himself is a candidate for a chairman. Those are different aspects.
Yes.
But here, what is happening here is that the vice chairman has already resigned. He has pre-resigned the chairman. So as on today, everything is in a state of a suspended animation. It was based upon that cause notes that show cause was issued to the board of the councillors. And the board of the councillors notes collectively, they never came back with a answer to the. Now, I can have my lordship for a moment also on my lord's. So from here, rule 5 also knows.
Rule 5 of?
Rule 5 of the rules.
Oh, yes.
It says that the vice chancellor, that the vice chairman has to report to the district magistrate that both offices are vacant. That he is also resigning. That also did not happen.
That also not done.
That also has not been done. Therefore, what happened was that rule 93C, red bit 341 was applied. Because the
Rule
91C, 93C.
93C.
But the problem, my lord, today is
9(3)(c), notwithstanding, I think the situation so demands owing to.
the problem, my lordship, today is that as per rule 6(3), there is no convening authority. Who will convene the meeting?
इतना जल्दी आए हाँ
So section 43, 1 and 2 read with rule 9(3)(c) is where the state intervenes.
No, 9(3)(c), according to you, the officer has to convene a special meeting of the municipality.
Oh, that was something. Then that is for the initial meeting.
Extraordinary.
Now, if I can have also for a moment on some of the provisions, other provisions not that are there.
No, why should 9(3)(c) not apply in this case?
9(3)(c), yes.
Yes.
9(3)(c) will apply only when
It's an extraordinary meeting, not an ordinary meeting. So extraordinary meeting, why 9(3)(c)
I will tell
should not be convened by the officer?
Oh, 9(3)(c) is not a self-executing mechanism. What happens under 9(3) is not that then everybody has to agree that there is a stalemate condition. It happens in furtherance of a stalemate condition.
No, who will agree? If the officer, if the situation so demands, owing to, it's not a question of agreement, because your submission is that it's a stalemate condition.
Yes, sir.
So then 9(3)(c) will apply.
In case of 9(3)(c), my lord, then who has to convene the meeting?
Officer.
Officer defined.
Officer has to convene a meeting.
Officer
You
is-
don't have the rules. Mr. Ghosh, you have a rules.
I have a printout. Officer defined it, definition.
Officer is defined in the rules.
Yes, yes, defined. District magistrate.
Yes, district magistrate or any other executive magistrate authorized by the district magistrate. So in its extraordinary case, if it is a stalemate condition according to you, that's the case. So extraordinary meeting ought to have been conducted, convened. 9(3)(c).
Millard notes this, Millard, with a caveat subject to hearing. Well, I have a different view of this. What should have been done?
That will not happen because no, there are two different kinds of meeting, an emergency meeting and a special meeting. This notes resignation and all has to happen by way of a special meeting as per 6.
As per?
6.
Yes, 9, special meeting is 9(3)(b).
9(3)(b).
And if special meeting cannot be held, then C comes. Emergent and special. If special does not happen, then
This is emergency.
yes.
Rule 13 for a moment.
Rule 13. Yes.
So general provision.
Rule 13(3), my lords, it talks about what is the procedure for the.
Yes, so chairman, vice chairman, if nobody, officer shall invite the councillors present to elect a
And the
president.
councillors shall elect a president,
President,
provided that the meeting, the proceedings of the meeting shall, till the chairman or the vice chairman or the president so elected, as the case may be takes over. So the meeting cannot be done unless not the president at least is elected.
yes, that has to be done. Once the officer conducts a meeting, calls first the chairman, chairman refuses, vice chairman not there, then the councillors. They have to then elect. So that steps have to be taken by the officer.
That is, then there is a doctrine of election, my lords. Because what happened was.
That's the duty as per the rules. Sir, those are the provisions in the rules. Meeting, who will call? Somebody has to call. It's a duty, cast an obligation upon the officer. In case you say stalemate.
No, stalemate is there in the record. Now what happens
So
is,
you say stalemate. If stalemate is there, then this will happen.
then in that case, not there is a doctrine of election. Either it could have been done this way or 431 would have been applied in case of a statement. Now, why did
Then,
the officer or why did the state chose 431 over this provision?
Yes. Where is that opinion?
That matter has to be looked into.
Show me that. Where is that?
Now, the opinion is that the board of
Mr. Where is that?
headless.
No. Where is that? You have to
No,
show.
it can be gathered from the documents. and the
No.
facts.
Yeah, that has to be a written opinion. A written document on the basis of which. Because 431 says there has to be an formation of an opinion. Opinion has to be formed. You are saying, Mr. Mishra, there are two things. Formation of opinion as you have distinguished the other decisions. According to you, in the other decisions, there were mass petitions. Alleging, no, that is, I'm trying to. So in those petitions, there were mass allegations, mass petitions alleging that certain things has been done. On the basis of that, 431 was taken. It has been said, no, it cannot be done. Now, 431 says certain preconditions are there. Now, for the purpose of satisfaction of the precondition, here, according to you, resignation of the chairman and the vice chairman gives rise to that situation. So, it's a stalemate condition because there is no one to convene a meeting. So, it's a stalemate condition.
Yes.
So, if it's a stalemate condition, for that 431, but where is that in the show cause?
So was not was
Show cause, Mr. you are doing in the direct access matters. The show cause has to be specific. What is the ground?
the so cause
Unless-
says that you will unable to convene a meeting to the board of councillors.
But the rules prescribes otherwise.
In the
Rules-
so cause, there are two things. One is said that as per such and such rules, you were to convene a meeting, or as per the act, you were to convene a meeting. You have failed to convene that meeting.
Officer was also obliged to do this. Officer was also obliged to do this. If the officer fails to perform its duty, for that, can 431 be exercised? When there was certain duty cast upon an officer under the statute or this rules.
क्यों नहीं दिखाते हम को सब हमको कितना अच्छा लगता है कोई तो बन रहा है मेरे जैसा
No, my submission was
17
there were two options that were available.
So according to you, there were two options. One is the board of councillors ought to have.
Because of the particular situation that arises in this fact. From the other cases, it cannot be compared. In none
No,
of
no, no.
those, Nobody resigned.
That
This
is
a
what.
completely different.
So so now we have to consider whether in a case where the chairman and the vice chairman of a particular municipality resign.
Both resign.
Yes.
This has never happened before.
Let us take, so this is the first case which has happened. Let us take this. That is the difficult thing to decide because if there is a precedent,
Precedent is there.
we will
that
be
have
coming
to
and saying, look, this is the precedent.
Yes.
This is the order. This has been decided. So the first case is the difficult one. The next is you can apply the law, you can cite the decisions, you can apply that. If it fits into that case. So now, according to you, in a case where the chairman and the vice chairman, because it's the board of councillors who has to, municipality has to function through the board of councillors. Now, the chairman is the head of that. He is to convene the meeting. There may be casual absence or vacancy in the office of the chairman. Vice chairman has to, yes, has to fit in that, because there's no particular provision powers in the of the vice chairman. He fits in when there is a casual vacancy of the chairman. So here is a case where the vice chairman resigns prior to the chairman.
And his resignation is accepted by.
Yes, yes. So he resigns, and that has been accepted. Now the vice chairman goes. Now the chairman is the only one. He also gives his resignation.
And he also does not agree to convene a meeting.
Yes, the larger issue is resignation not accepted. Second, third is he is not willing to convene a meeting, because as per the rules, he has to convene a meeting for acceptance of his resignation.
Yes.
Now he does not do that. One is, there is 6(2)(a), you said that there is a prescribed procedure for accept.
What has to happen once the resignation is ratified.
Yes, yes. So at the stage of ratification,
Yes.
that is 6(2), those time limits for the purpose of ratification. Now that's pending. Then what would happen? Whether such situation can be a ground for exercising 431, that's the issue which is to be decided now. Because that is the issue. Because that's the stalemate condition. Chairman is not there, vice chairman is not there. Nobody is willing to call for a meeting.
Yes, no.
So it's a stalemate condition. Now the situation is whether that can be a ground for 431.
Yes.
That is to be considered. Anything more you want to submit?
I would just talk about a couple of constitutional provisions that are there. He has already relied upon your 243U. I think that needs to be read with 243ZF and 243P. If I'm not wrong, madam. Because I will explain what it is. Even there is
243.
just a moment.
You want to place 243U first?
243Q and 243ZF. Because
Q and ZF.
as per 243Q, Lords, the state has the duty to look into the affairs. And as per
243Q.
As per ZF, Lords, the state acts as a supervisory jurisdiction over the municipality. The 43Q, Lords, duty to ensure that the city communities are supplied.
It's okay. Constitutional municipality.
Q is Constitution of Municipalities.
Yes.
Provided the municipality under this caution may not be constituted. What are you, which provision you are pointing out? 243Q is Constitution of Municipalities.
Maybe my notes are not correct. 243 ZF for a moment.
बुक नहीं आता
No, this is the existing laws continuation. That's a different thing.
You are
मामला चलছে পরে
just a moment.
চলে চলে घर में सबका गार्जियन नाम ही है किसी को चीखना भी होता है हम लोग नहीं पता ठीक है
I'm so sorry, 243 W.
243?
W.
फोन से व्हाट्सएप में वो स्कैनर भेज
Two 243? ZT is the last one.
I will. It just says that the state has a supervisory jurisdiction over the municipality.
That is not in dispute. Supervisory jurisdiction has to be. Anything more? Yes, Mr. Ghosh.
Yes, please. So let the reasons for passing the order dated 3rd July 2026. Yesterday, Milord has considered. I will just read it once again, Milord, for my satisfaction.
From where?
From page 29 of the writ petition, the order, the final order.
Yes.
The last paragraph. And whereas, considering the situation prevailing in the Alipurduar municipality, after tendering resignation of chairman and the vice chairman of the said municipality and failure to hold meeting of board of councillors of the said municipality to give reply to the said show cause notice order within specified period, but I pause here for a moment, it can be stated that the Board of Councillors of the municipality is not in a position to carry out in functions and to provide normal civic services. So, my lord, the grounds are failure to hold board meeting of the councillors, number one, disjunctive, and to give reply to the said show cause notice within a specified period. Now, my lord, admittedly, the putting in of the resignation of the chairman as well as the vice chairman is not in dispute. Resignation has been put in. Now, how to deal with that resignation is 6.2c, which your lordship has already considered. Kindly now, my lord, take 6.2c once.
Yes.
The marginal note is, my lord, slightly, I would say, my lord, confusing. 6.2a, my lord. 6.2a, my lord. 6.2a, I'm sorry.
Of the rules.
Of the conduct of business rules.
Yes, yes. 6.2a.
A.
Yes.
In case of any vacancy in the office of the chairman caused by the resignation, within 7 days or as soon as thereafter as may be, but not later than 15 days of resignation by the chairman, a meeting of the Board of Councillors shall be convened by the chairman or on his failing to do so, by the vice chairman within 7 days thereafter, or on his failing to do so by any three of the elected councillors within further 7 days thereafter. Why? This is important, my lord, for acceptance of the resignation or otherwise. So 6.2 or 6 rather deals with how to deal with the resignation.
Yes.
Accepted, rejected, ratified, whatever. Timeline is there. Admittedly, chairman and vice chairman is not there. They're not willing to join the exercise. So the third contemplation as to how the Board of Councillors would have to do it. Now, Millard has also seen the timeline 15.7.7.
Now, here, the vice chairman's resignation has been accepted.
Yes.
There's no
Accepted by the chairman.
Yes.
Yes.
So that's the procedure.
That is the procedure.
So now the vice chairman is not there.
Not there.
So now how the timeline will be calculated?
A chairman who is there, but his
Yes.
resignation not accepted.
Yes. So
Yes.
this timeline, so chairman is not calling the meeting.
Chairman cannot call the meeting. He is not
Yes.
willing to do so.
Yes.
Vice chairman is not there.
Is not there.
The
So
third
now is the
contemplation.
3 councillors have to do that.
3 councillors. The stage can only come after expiration of the first 15 and thereafter the first 7 days by the vice chairman.
Why?
By the vice chairman.
But in a case,
Is not there. It is
in a
15+7.
case,
Even
there
then
is a
it is,
case.
even then, assuming he is correct, then even then 15+7.
No. Yes. So it's there are 2 things. So now first
Yes.
we have to consider the timeline first. Then
Correct.
whether you fall within that or he falls within that, that's
Yes.
the different thing. So first is the 7 or soon thereafter, as
But-
maybe not later than. So
But
outer
not
limit is
later than.
15.
Outer limit is 15 days.
Then
15 days of resignation by the chairman.
yes, so resignation,
Resignation
is 18th.
is on 18th.
So 15 days from 18th, then whether the second 7 days will come in or not,
The second 7 days will be coming after the expiration of this.
will come in this case or not, when the vice chairman is not there.
The third 7 days will come in 15+7 instead
Yes,
of
but not the
15+7
second
plus
one,
7.
not the vice chairman.
Let us proceed on that basis. Very well. Let us proceed on that basis. A meeting of the Board of Councillors shall be convened by the chairman or on his failing to do so by the vice chairman within 7 days thereafter, or on his failing to do so by any 3 of the elected councillors within further 7 days thereafter. So vice chairman is not there. Outer limit for the chairman 15 days. He says, I am not willing to come. Do whatever you want. 15 days goes. By this Board of Councillors, 3 members of the Board of Councillors within a further period of 7 days. So 15+7, there is no doubt about it.
22.
22 days. Even then, their action is within the period. Now, Millard, the most important provision which will, Millard, dispel all the clouds. Please take, Millard, section 17(4).
17 4, Mr. Mishro referred to, then suddenly he slipped over that and proceeded to the next section. But there is my question to you before you place section 17.4. At what stage this will come?
I will,
Whether it's after 16.2a or prior to that.
the section itself is answering to your lordship's question.
Yes.
17.4.
Yes.
In case of casual vacancies in the offices of both the chairman and the vice chairman caused by death, resignation, removal, or otherwise, the state government may appoint by name one of the councillors to be the chairman.
Now,
The
Mr. Ghosh,
resignation is not ratified.
that is why my question to you is, I have seen this provision because after placing, Mr. Mishra realized he switched over to another
So the
section.
resignation was not ratified.
Now the question is,
That's
at
why
what stage
that's
this
why
section 17.4 will apply? No doubt the state government has a duty to appoint,
or otherwise.
but at what stage? Whether it's after ratification or pre-ratification.
Now,
That's, please submit on that.
Now, Millard, looking from the point of view of the state, when you look at a municipality where there is no chairman and no vice chairman, you have two options. 6.2c, there is a procedure to deal with
6.2c
the
or A?
2a, Millard.
Yes.
6.2a, either you wait for the timeline, you see whether the board of councillors act or not, or if you feel there is an exigency, you invoke 7.4, because otherwise is there. It's a residuary expression.
Otherwise is,
The casual vacancy is there. Admittedly, Millard, whether resignation ratified or not, the vacancy is there. By death, resignation, removal, or otherwise, it's wide. So instead of waiting, if
so
you
according to you, otherwise will include a situation
all other situations
Yes.
where there is no
where
chairman
no
and vice
ratification
chairman,
has been made.
no ratification has been made, or any other situation where chairman and vice chairman is not available. Maybe both fall sick together for 6 months, undergoing surgery, both of them, it can happen. The
Yes.
act contemplates everything. That is the presumption of a legislation. So either you wait for the board of councillors to act in accordance with 6.2a. Still, if you feel there is an exigency, the public utility services, civic services is being affected, you had the option to invoke 17.4 and appoint a councillor to act as the chairman.
Yes.
So this stalemate causes omniscience, municipality in limbo, what else we could have done? You had a duty which the statute provides. You failed to discharge this duty under section 17.4. So now, Millard, assume a situation. Millard, kindly assume a situation. Say this show cause and dissolution order has not been published by the state. Let us assume a situation that this show cause dissolution order is not published by the state. Today, in the month of August, what is the situation?
No, I
Chairman
could
and
not
vice.
follow. Please start. on
Millard,
this.
Millard, assume a situation kindly that this show cause and the dissolution order has not been issued by the state. There is no writ petition today. Chairman, vice chairman has resigned. The board of councillors, for this good, bad, indifferent reasons, they are not acting in accordance with 6.2a. What the state would do?
431 they have done.
One option, they have done correctly, incorrectly, your lordship's consideration. According to me, they should have invoked section 17.4. You appoint someone, a councillor as a chairman, and ask him to discharge his duties in accordance with the law. The statute had the remedy. You ignored this. and you invoked a provision which is extremely drastic and which is only applicable when there is an opinion formed that by whatsoever reasons, nothing can happen, no services can be delivered, everything has gone. That is a drastic provision. And Millard would remind this in mind, Millard, that the 5-year tenure of each of the councillors are protected by the Constitution, save and except taken away by operation of law.
So Ghosh, have you got hold of any decision with regard to this, otherwise defining this or?
No, it will not
Inter-
apply.
no.
I will explain.
All right,
Then
Mr. Biswas, I will come back to you. Let him conclude, otherwise.
No, Millard, to be very candid, no. In the context of 17.4, no. Otherwise, Millard, there are, Millard, otherwise, adjustem generis, Millard, there are several decisions where, Millard, continuation of a general residuary expression has to be read alike the other expressions. Millard, we can get it from SCC. Millard, if Millard gives the citation, Millard.
By the time that happens,
Millard will try to find out.
Section 92 of the land contract.
Google में मारो ना पहले. Section
No,
92 of Land Reforms Act.
Our understanding of 17.4 million.
Land Reforms Act in 1992. So Millard, this invocation of 431, Millard, apparently is absolutely misplaced because of the grounds that they themselves have stated. The basis is resignation of chairman and vice chairman, resultant malfunction or dysfunctioning of the board of councillors, further resulting into their inaction in replying to the show cause notice. So the genesis of this entire order is, Millard, the absence of the chairman and vice chairman. Now 17.4 contemplates. Yes. Yes. Coming from that. So either you undisputed position. So either you would have waited till the time frame of 16.2A was exhausted, or you could have instructed the board of councillors to act in terms of 6.2A. You have that supervisory jurisdiction, or you had the power embedded in the act itself to pick up this power under section 17.4 and appoint a councillor as the chairman.
So according to you, a situation like this, it has a plan under section
17.4.
Instead of
Two options. First, I say to compel the board of councillors to act in accordance with 6.2A, to accept his resignation and elect someone, or to resort to section 17.4. Now, Millard, one thing which your lordship would consider very important, 6.2A only deals with how the resignation has to be dealt with. Nothing more than that. Now, who will take the decisions? Board of councillors, but the specific functions assigned to the chairman with regard to conduct of meetings, discharge of functions, and the entire business rules, Millard, is centric to the chairman. That's why 17.4 contemplates that you could elect a councillor as a chairman until the new chairman is elected.
As in this, the vice chairman has resigned, chairman has been there with him. And chairman is also agreed to conduct
Meeting.
and three councillors, let us think that section 6(2) is compliant.
Yes.
So 6(2) within that time, let us.
Yes. Yes. Yes.
Within that window of 21 days, this three elected members call for a meeting. They can do that.
But that is, with that meeting will be restricted only for the purpose of acceptance of the resignation.
Only for the purpose of acceptance of the resignation.
Yes.
We need to say that even for that,
You have to ultimately revert back to 17.4.
for that also,
Yes.
acceptance.
No, not for acceptance.
So that is what I asked.
Yes.
So this was different situation.
That's why, my lord, the hypothetical situation which I placed before your lordship, assuming that the board of councillors is not taking any decision, they are not acting in terms of 6(2)(a).
According to you, those submission is the father's.
Yes.
Three elected, any three elected councillors can call for a meeting in regard to the acceptance.
Correct.
It's not accepted.
It's not accepted.
Let us take both ways.
Both ways.
Not accepted in the chairman remains.
Remains.
Nothing is other things 74 does not come.
Does not come. But if my lord,
Resignation accepted.
resignation accepted, chairman goes. So I fall within casual vacancies arising out of resignation.
Then the next option is 74.
Next option is 17.4.
So my question to you is whether section 17(4) is coming
After 6(2)?
or
Yes.
after 6(2)?
Yes.
Please answer.
My lord, 6(2)(a) contemplates a chain of events. 6(2)(a) contemplates a chain of events. The chain of events is with regard to acceptance of the resignation of the chairman.
Is whether 17(4) has to be resorted to pre-6(2)(a) or post-6(2)(a).
According to me, it is post 6(2)(a). Because since the conduct of the business rules, which is
So it's after 6(2)(a).
after 6(2)(a).
So according to you, if the councillors not act under 6(2)(a), then for the purpose of acceptance of resignation also, 17(4).
17.4 can be resorted to because 17.4 contemplates one councillor. Yes. 1 councillor comes in as a chairman, then he can again fall back to 6(2)(a) to consider the resignation. Say, my lord, the resignation of the chairman is not accepted. 6(2)(a) by the remaining board of councillors, they did not accept. The timeline gets over. That's 15 plus 7 days timeline gets over. The board of councillors doesn't act to do anything with the resignation. The state has to fall back to section 17(4) to appoint someone as a chairman from within the councillors. Now that chairman, who is appointed by the state, can again fall back to 6(2)(a) and consider the resignation. Because from when this timeline will start, that is also stipulated.
Yes, so according to you, after the three elected councillors do not act, then state has to appoint, then the appointed chairman has to call a meeting for acceptance.
He can, for acceptance of the resignation. The idea is to keep the situation functional, and the statute contemplates everything because the tenure of 5 years is guaranteed by the constitution. Except operation of law, you cannot do anything with it. And therefore, this otherwise has been included intentionally to apply to such situations which has not been contemplated. In general, my lord, in our day-to-day walk of life, my lord, how we can be confronted with death, we can be confronted with resignation, we can be confronted with removal. These are the general things. But there may be 108 situations where the chairman and vice chairman both are not available. As I said, both of them fall sick together. It can happen. That's why this is, my lord, white or otherwise. Any situation where the chairman and vice chairman is not available, there is a vacancy. It cannot be infinite. Someone has to step in with the strength of law, by sanction of law. That sanction is 17(4). Dissolution, my lord, is much higher parlance, on much higher parlance. And when the statute provides something, instead of discharging this obligation, you cannot do something on your whims. That also without recording any reason. Without recording any satisfaction. Without disclosing in the show cause that why you are satisfied. Now, my lord, takes the wordings of 431. It is very drastic. Power of the state government to intervene in case of gross neglect or serious irregularity. If in the opinion of the state government, the Board of Councillors has shown gross neglect in the performance of the duties imposed upon it by or under this act or any other law for the time being in force, or has committed serious irregularities in the performance of such duties, the state government may by order direct the Board of Councillors to show cause.
So according to you, this increase gross neglect committing serious
irregularity. जल्दी निकालो 1991 1 CHN 11 1 CHN 11
Yes. Yes.
So, beloved, the
So according to you, there are two important expressions.
correct.
Another is committing serious irregularities in the performance of such.
Yes. So non-performance and irregular performance.
Irregularity, you may say yes, but if Board of Councillor not take steps in accordance to 6(2)(a),
They have neglected.
can you not say that it does not come within this gross neglect in performance?
That stage had not yet arrived. The stage had not yet arrived.
Because the timeline has not expired.
Timeline has not expired. And just because the timeline has expired, straight away you cannot come and serve a show cause, you have to mandate. Gross, it is, my lord, gross neglect, not neglect. Negligence of a higher degree. So we would have understood after you wait till the expiration of the time period, you serve notices that see under 6 to have a duty to perform, you immediately convene a meeting and do in accordance with the rules. You serve 2-3 notices, they don't act, then the negligence becomes gross. And then you invoke 431. It's not that easy. The expression is gross negligence. The negligence has to be on a higher pedestal, higher degree of negligence. Serious irregularities. Serious. So even then, non-performance of 6-2A cannot be a handle for them to issue this show cause. And as I have at the cost of repetition, otherwise, expression contemplates all situations alike, the result of which will be non-availability of the chairman and vice chairman. That would be the test. Any other situation,
Both are not there.
both are not there.
Or, in a way, both are not willing to act
Both are not willing to act.
as per the provisions of the statute and the rule.
Yes, they have to be treated as absent.
According to the rule, is otherwise
Broadly construed.
expression which
Includes any situation which will result in non-availability of the chairman and vice chairman to discharge their functions in accordance with the law and the rules. I come and sit in the municipality is not sufficient. You have to discharge your duties in accordance with the law. If you don't do that, you had the power. Otherwise, interpretation. That's all, Millard. No, if Millard has any other queries, Millard, I can try to Millard.
Let's start with 17.4 for a moment. In the case of casual vacancies in the offices of both the chairman and the vice chairman caused by death, resignation, removal, or otherwise. Now, the way it is trying to be interpreted, why it will not apply. And an example was also given that if the chairman and the vice chairman, if they fall sick or if they come but they do not perform their duty, then also it will fall within this clause. No. Why I say? In case if there is a death, a person dies, casual vacancy is there. In case if there is a resignation, a person dies, a casual vacancy is there. In case if somebody is removed, the person dies, the person is removed and the casual vacancy is there. In case if somebody is sick, he is still the chairman or the vice chairman. In case he comes to the office and does not perform his duty, he is still the chairman and the vice chairman. Therefore, 17.5 cannot precede 6-8. A resignation has to be there. Then only it will fall within 17.5. But today, the resignation is there. But the resignation is not a ratified resignation. So this has to be construed adjustum generis. It cannot be construed nociter associis. Because the three examples that are given here, death, resignation, and removal, in all these three cases, somebody is losing his post or is not available for the post. So it cannot be construed as an example wherein somebody is falling sick or somebody is coming and not performing the duty that will result in a casual vacancy. No, it will not. There is a difference between the expression. This otherwise, therefore, would mean something similar to a death or resignation or a removal. And that is where Miller has said that there is a little bit of a casus omissus that is there. Now it is always for us to interpret it the way we want it, but the statute, when it was drafted, it didn't contemplate such a situation.
Otherwise has been defined. This interpretation not this context. That
is it, Everything else has been addressed before my lordship. Everything else has been addressed before my lordship. And that is why, when I initially referred to this, But the moment the resignation was there, I detracted back. Because it is not falling under that category.
Milord, may I have just 2 minutes leave, Milord, of your lordship? So washrooms. Yes, sir. Well, I'll just go to the washroom and come back.
Four councillors. Only that is also point, Milord. The quorum is not here. There are only 4. The quorum consists of 7. Without prejudice to somebody who has gone for a nature call. Yes, their letters are also there. One of them is the councillor of ward number 20. One is the councillor of ward number 18. One is of 3. And one is the councillor of ward number. The list is there at page 20.
Yes, Milord. Petitioner number
1 Milord, is the councillor of ward number 20.
Yes, Milord. It has not been mentioned.
20. Not
Yes,
20.
but they are all councillors.
Admitted.
4 councillors of Alipurduar municipality has filed this petition praying for setting aside the show cause notice dated June 30, 2026. The order of resolution of the municipality dated
3rd July.
3rd of July 2026, and the order dated 3rd of July 2026, appointing and sub-divisional officer Alipurduar as the administrator of Alipurduar municipality. That's giving rise to this in a nutshell.
Yeah, there you go.
The Vice Chairman of Alipurduar municipality.
Vice Chairman is her.
The statement of facts is
Oh no, Mampi Adhikari.
what's done then?
The Vice Chairman is she is the female.
General President.
General President.
He's an app.
On the office of the Vice Chairman on Was accepted by the cabinet of Alipurduar of the same day. The chairman of the municipality by a letter dated 18th of June 2026 stated his resignation from the from the office of the chairman of the state municipality.
After accepting the resignation of the vice chair.
It's the opposite. Of the Alipurduar municipality. By order dated June 30, 2026. Directed to the Commission of Alipurduar municipality to show cause as to why the municipality shall not be dissolved. As to why the board of councillors should not be dissolved. On the grounds stated in the state law. Petitioners. Petitioners declared
All the four.
All the four.
the petitioners hearing. Submitted in time. So possibilities. Only executing officer. Alipurduar municipality. By latest dated July 3, 2026. The additional secretary to Calcutta passed a law and order dated 3rd of July 2026 was passed in exercise of the powers conferred under section 231 of the West Bengal Municipal Act 1990. Thereby, dissolving the board of councillors of the same municipality. So it's immediate. By another order dated 3rd of July 2024. Subdivision officer Jalpaiguri for the advantage of the administrator of Calcutta, which immediately for period not exceeding 6 months or until the duty board of councillors take charge from whichever is. the executive officer by memo dated 7th of July 2026 intimated the councillors of the Alipur municipality that the board of councillors of Alipur municipality should dissolve the immediate effect. We agree the petitions have approached this. So those are the many on the rates that every result can continue for a period of 5 years from the date appointed for its first meeting, unless say is dissolved under any laws for the time being. Submits that the municipality shall have to give a resident opportunity of the for its solution. So, in support of such convention, it places land of Article 246 of the Constitution. So those conditions that a duly elected board of councillors should not be dissolved in what is by citing the powers under Section 431 of the West Bengal Municipal Act 1990. Subjects that other subjects that the state government can pass an order directing the solution of the board of councillors only on the grounds mentioned in Section 421 of the 1990 Act. After according and opportunity, the board of councillors will focus on the not convince the state government. Submits that the order dated out of July 2026, resolving the board of councillors of the municipality with initiating effect do not record any satisfaction as to the grounds contemplated under section 431 of the 1993 therefore submits that the those places land upon the decisions of what they did is an order dated 16th of June 2025, passed by a coordinate bench in WPA 118 in the case of Girish Shukla versus State of and the order dated dated passed by another coordinate bench in WPA 1187 of 2026 in the case of provision for last in support of this message that constituent of a elected local body is serious nature and must strictly conform to the established framework and no deviation from the procedural prescribed so those who are glad about this speeches.
Yes, yes. 3 Millard. Millard, Mysura Begum, WPA 486.
Mysura Ravishankar and
Mysura Ravishankar and Dinesh Shukla. Justice Rajabashu Chaudhary.
What can be this statement of tax?
It got entangled. It was not.
Suppose for some ways that the qualities involve the provision is laid down under section 451 of the 1990 Act. Manage the same as seriously made by subjects and shall decide meetings of the Board of Council. Further submits that in case of any casual vacancy in the office of the chairman caused by death, resignation, removal or otherwise, the Board of Councillors shall elect one of the councillors to fill up the vacancy. So, it submits that in case the which is subsequently vice chairman shall, in the absence of the chairman, decide the meetings of the Board of Council. Further subjects, when in the case on hand, in the instant case, the vice chairman has tendered his resignation. Her resignation, which has been duly accepted by the chairman, and the chairman has also tendered his resignation to the Board of Councillors. It submits that as per the provisions of section 2, section 6, with bracket 2 with bracket small a of the West Bengal municipality, bracket procedure and conduct of 1995.
That is the rule, man.
Its rules.
We had said section 6, it should be rule 6.
For short, 1995. The resignation of the chairman has to be accepted by the Board of Councillors. Subjects that the chairman of the municipality has already expressed his intention orally to the executive officer of the municipality that he is not inclined to call the meeting of the Board of Councillors for the acceptance of his resolution. Further subjects that in the absence of the since there is a casual because the office of the vice chairman and the chairman.
Before that, not it was only the chairman who could complete that meeting for acceptance of his resignation, which he failed.
Then since there is a casual because in the office of the vice chairman and chairman also got interest in calling committee for acceptance of his resignation. A statement condition has arisen.
That meeting ideally is convened by the vice chairman.
Has arisen insofar as the function of the municipality is it subjects that in such a situation it was for the
Even after his resignation, he remains a councillor. Part of the views.
for the
No,
elected
chairman's
councillors
chairman's resignation, but still is a views.
call for a meeting
Therefore, he is a part of.
within a specified time for the purpose of acceptance of the resignation of the chairman. So far the subjects that since the Board of Councillors had shown gross neglect in the performance of their duties by not conveying anything in the manner as contemplated under Rule 6 within brackets 2 of the 1995 rules. And no show cause notice under section 471(1) of the 1993 Act. It further submits the since no reply to the shades of possibilities was submitted by the authorities within the time limit specified in the statute. The so-called notice. State government dissolved the Board of Councillors by the order dated out of July. Yes, sir. By the order dated out of July. When it was published, it was
We do not have that. We do not have that. Usually it is done, thereafter not the elections are called. Once the dissolution is there, then thereafter the elections are called. That is there in the. Oh, I need. We will figure that. Yes.
You can take a copy of
The gadget.
Order of dissolution.
Resolution.
कॉपी फॉरवर्डेड में गैजेटर के पास नहीं दिया हुआ है जो पब्लिशन वाला होता है कॉपी तो लिखा रहता है कोलकाता गैजेट नहीं हुआ
तो नहीं शिक्षण अप्लाई करो ऐसा काम कर
इसका तो काम बन गया फोन करते सब करो बहुत पता नहीं क्या
in support of this contention. The chairman was convened the meeting of the municipality. So we saw this lands on provisions of 9 of the 1995 rules. This was something that the decision relied upon by is distinguishing facts as in all such cases the foundational basis of the so-called where mass issues and mass complaints by the local people arranging disruption of municipal. It thus permits
It will happen in due course. Not because the chapters are- Oh, it has been given to public. Till not. So sweet. So cute.
Thus submits that the same decision that upon by do not have any manner of on a query of Mr. on instructions. Instructions submits that till now, that is in the previous period, the order passed under section 431 bracket 2 of the 1993 Act has not been published in the official. The reply supposed to subjects that the section 6 bracket 2 bracket 3 of the 1995 related various guidelines for convening a meeting by the chairman and on this failure by the chairman and on his failing to do so by the vice chairman and if the vice chairman also is by any three of the elected councillors within further 7 years.
उस प्रोविजन का सिमिलर प्रोविजन वाइस चेयरमैन के लिए है कि नहीं चेक करो 74 जैसा
That as per the provision of section 6 with bracket 2 section 2 with 6 with bracket 2 with bracket A of the 1995 Act. The time limit for convening meeting by three of the elected councillors. Expired after expiry of it's 50 plus 7 plus 7. After expiry of 50 plus 7 plus 7. That is 29.
29, 22%.
29 days from the date of issuance of the resignation letter by the so subjects that long prior to the expiry of the state mandate, the Chocos notice was issued on 30th of June 2026 and the order of resolution of the Board of Council was passed on 3rd of July 2022. The subjects that the state government the subject that there was something that is not a case of gross negligence in the performance of the duties imposed upon the Board of Council by the 1990 Act and so those were the subjects that since it is a case of casual vacancies, the officers of both the chairman and the vice chairman, the state government was under a statutory obligation to appoint by me one of the councillors to be the chairman shall hold office until a chairman is elected under provisions of subsection 3 of section enters upon these forms. So the base the expression otherwise used in subsection 4 of section 17 to cover instant danger wherein the resignation of the vice chairman has been accepted and the resignation of the chairman is yet to be accepted. Paragraph Mr. So implies a base that the provisions of Section 17 can only come into play after the resignation of the chairman is accepted in the manner as contemplated under Rule 6, bracket 2, within bracket small a of the 1995.
Yes. And this is the casus omissus that is there in the act. This more or less is the casus omissus that is there in the act, because the act never contemplated a situation like this.
On the surface, that the act surface that the act is the act as well as the rules framed thereunder are silent as to what would silent as to the procedures that has to be followed in a case of like any cases which are missed.
No.
Article 100 is of importance and purpose of signing disputes raised involved to the beneficiary to calculate the provisions of Section 431 of the 1993 Act. See that. Section 431 of the 1993 Act.
মানে আপনার ব্যাটার ফরওয়ার্ডার ছিল তো আজকে পাঁচটাতে রিচ করে যেত তখন জোর করে আমি এখন করবো না বসান যাবো দুটো স্টুডেন্ট তার এই চাকরিটা ভালো
Opinion of the state government. The use of such expression would imply that there has to be a formation of opinion by the state government that the Board of Councillors has shown gross neglect in the performance of the duty imposed upon it by or under this act or any other law. for the time being years, or as counting serious neglect in performing. Only upon permission of such appeal, state government by an order shall direct the Board of Councillors to propose within the period specified in the order, by it shall not be dissolved. On the grounds of that nation and exceed. Well, this matter was taken up for him on so issue of findings, taking the facts on 29.
Yesterday,
The last day.
Yesterday.
This matter was taken up for hearing on
Only when Mr.
29th of July 2026.
Not before.
A statement of facts along with several documents were filed by Mr. Vishnu, which were taken on record. A copy of such, a copy of the bunch of documents were also supplied to Mr. Ghosh. From the documents filed by the state, it appears that the vice chairman tendered a resignation from the office of vice chairman by later dated 18th of June 2026, the chairman and the chairman by later dated 18th of June 2026, addressed to the Board of Councillors and to the informed the Board of Councillors that the resignation tendered by the vice chairman was duly accepted by the chairman. On the same day, that is on the 18th of June 2026, the chairman, by a later dated 18th of June 2026, tendered his resignation from the office of the chairman to the Board of Councillors. So, the executive officer by a later date, 22nd of June 2026, requested the chairman of the Alipurduar municipality to convene a meeting of the Board of Councillors of the municipality at the earliest convenience. As per the provision of Rule 6 within bracket 2, within bracket small a of the 1995 the executive officer Alipurduar Municipality later dated 27th of June 2026 brought to the notice of brought to the notice of the magistrate Ali that on 18th of June 2026 the chairman stated his resignation to the Board of Councillors to the executive officer and the vice chairman had also submitted her resignation to the chairman. It was accepted in the same letter. The executive officer stated that executive officer recorded his privacy observation that as per the verbal it is not very conveying any meaning regarding his resignation and the vice chairman too will also not convey any meeting in connection with the chairman's resignation. In anticipation of a major statement regarding administrative issues of the Alipurduar Municipality, the executive officer is to intervene and resolve
ये प्रोफेशन तो सब लिख के देगा वो तो पढ़ के नहीं देगा
district magistrate will start address the letter. The additional things
ना उससे आपको दिक्कत नहीं है
urban development and municipal affairs on the recent development. And that no meeting of the Board of Council has been conveyed till the date of issuance of the same letter, that is on the 27th of June 2026. We show cause notice dated 30th June 2026, issued by the Additional Secretary Development of the appears to have been forwarded by the executive officer Alipurduar Municipality to the individual the councillors of the respective wards of the same municipality. Thereafter, and thereafter the order, the Part of July 2026, resolving the Board of Councillors of the state was passed on part of July 2026. And subdivision officer Jalpaiguri was appointed as an administrator. Subsection 2 of section 231. Subsection 231. States that the state government will resolve the Board of Councillors and order published in the official gazette with effect from the days of the order.
तुम लोगों में समझाया कि कंप्लेंट केस का वाशिंग के लिए सॉलिड कोई ग्राउंड मिल नहीं रहा, बट दिस विल बी वेरी गुड ग्राउंड एनसीएलटी में चला गया. Now the entire
as it transpires from the submission of the learned assistant additional the order resolving the Board of Councillors has not yet been published in the official. The question that arises from consideration is whether resignation of the vice chairman and the tendering of resignation by the chairman pending without the same being accepted in a meeting of the Board of Councillors can ground for exercising that's been a ground for exercising powers under section 31 of the 1990. For such purpose, it would be relevant to take note of the provision of 6 in bracket below.
विटामिन पियोगे टैबलेट
Otherwise, what means what?
घर जाएगा चले जाओ
कल तक रहता हूँ
ना सिलीगुड़ी नहीं बोलता यहाँ पे कैंप पे वापस शाम में तो आगे रिप्रेजेंटेशन भी बनाना है अच्छा करके बनाना है
देखूंगा क्या
Chairman is compliance of the Board of Councillors.
तुमको ये वकील बनने का आइडिया किसने दिया?
15 days.
सुबह दार्जिलिंग में आराम से नौकरी कर रहा था, सुबह छाता लेके धीरे धीरे
All municipality
2 बजे तक घर वापस
by
गिटार से चली रहा था।
within 7 days thereafter.
उन सब को कुत्ता काटा था।
Of the elected councillor.
प्रैक्टिस में तो प्रैक्टिस तुम्हारे डेली बीच 40 by 50 ऐसे तो 20 के बाद करना ही पड़ेगा। तो कैसे होगा?
Thus, it is evident that we are tendering
कर रहा हूँ, improve हो रहा है।
does not amount to resignation, does not amount to vacancy in the vacancy in the office of the chairman, unless such resignation is accepted in the manner prescribed under the same. So, it is also open to the Board of Councillors not to accept the resignation in view of the expression otherwise used after the expression acceptance of the resignation. Certain view of this situation with the resignation of chairman is accepted by the Board of Councillors. Then within the time limit mentioned clearly, the vice chairman has to the chairman is continuing office must be taken to all on his spelling so by the vice chairman and thereafter the councillors shall have to convey paragraph the instant case the chairman tendered his resignation later than his 18th of June 2026. So, 15 days time for the chairman to convene a meeting for acceptance of his resignation as per the 6th won't expire. What would be the 3 days?
2nd July.
Expire on 2nd of July 2026.
वो नहीं करता है, next Friday councillor, vice chairman तो है नहीं।
Accepting that since the resignation for the resignation of the vice chairman has been accepted, the time limit mentioned in the same proviso for the vice chairman to call a meeting is not cannot apply. The time limit for the three of the elected councillors to call for a meeting after the expiry of the aforesaid time limit would expire only on 9th of July 2026. Thus, on a day, any day prior to 9th of July 2026, it could not state that there was any material, there was any basis for formation of period by the state government that the Board of Councillors has shown gross neglect in the performance of the imposed upon it by not meeting in accordance with the provisions of Rule 6.
You are now going back to 3rd July.
1995.
Now you are being reverted back to 3rd July the situation.
In the case on hand, the executive officer violated the 27th of June 2026.
3rd July को ऑफिस जाना पड़ेगा ना. 3rd July में कहाँ ये start हुआ? 3rd July में क्या तो हो रहा है वो भी नहीं है. अब 16th day में you still have 6 days.
To immediately intervene in the matter in anticipation of a major statement regarding administrative of the municipality. So, this would fails to understand as to what prompted the executive officer Alipurduar municipality issue such a notice within 9 days of tendering the resignation letter by the chairman and prior to expiry of the 15-day time limit given by the prescribed by the by Rule 16 that small a of the
executive officer को पार्टी बना
chairman convene a meeting of the Board of Councillors to accept the resignation. So, that apart, the section 431(1) states of issuance of a protest notice and an opportunity to the Board of Councillors to give reply to answer to the charges. The time limit specified in the say after going to the possibility for 5 years, that only 3 days time was given by the was given to the Board of Councillors to give reply to the so-called notice. Such a short period of time Clearly considered view of the code, cannot be said to be sufficient sufficient opportunity to this board of councillors to answer
Discussion. The consequences of grave rates for minimums happening to all. When after reasonableness, तो अलीपुरद्वार का बात बोल रहा हूँ एसडीओ अकाउंट होने के बाद कोई काम नहीं होता है पूरा वाला को कौन झरेगा मेरा तो माफ करता है गुरुद्वार का शहर गली सब पूरा सा भर गया एसडीओ आता ही नहीं है
except so-called notice only states that after submission of resignation by the vice chairman and chairman, no meeting of the board of councillors has been conveyed till date, resulting in the same meeting situation and the same opinion apart from what's the grounds, no other grounds I take in the so-called notice. The grounds cited in the so-called notice. The mind of this ground cited in the so-called notice cannot be said to be all within the expressions gross neglect the performance of imposed upon the place by or under these acts. Or has committed serious irregularities in the performance of such duties. For all the this would therefore hold that the so-called notice and the solution of the councillors lacks the conditional basis as contemplated self-regulation. One till bracket 1 of the 1993 Act gives a person the time to interfere with the order interfere with the so-called notice order of resolution and the order the order of resolution order of and the order of appointment of the administrator.
पूरा खुश हो रहा है तृणमूल का जीत কি করবো এগুলো তো ইম্পর্টেন্ট বলো না খালি সুপারি বার করলে হবে কোন লাগবে পরে সার্কিটে কোনো মানে উত্তরে এসে করছে মক্কেলকে একটু কনভিন্স করো মক্কেলকে একটু কনভিন্স করো কয়েকদিন ওয়েট করে অনুরোধ ধরে গেছে হয়ে যাবে সুবিধা হতো কিন্তু এটা হবে না সকালে বলছিল না ওদের থেকে মেরে দিবে ওরকম কোনো
Taking steps.
Great. বৃদ্ধ তো গাড়ি নিয়ে ফটাফট grateful milord.
My lord,
Your lordship.
My lord,
Very
my lord,
grateful to lordship, my lord.
my lord, kindly tomorrow.
My lord,
My lord.
My lord, lordship.
item number 40.
My lord, for the next term, for the next matter, item number 40 through Mr. Arindam Banerjee is appearing, my lord.
For your urgency.
Your lordship, may I mention?
150 to 150, my lord.
My lord,
Lordship,
my lord,
Lordship,
item
you're
number.
rising, Lordship, only one thing.
Your lordship, may I mention serial number 46?
My lord, item number 48.
Serial number 46, your lordship.
শেষ ভোট উঠে গেল এই সার্কিট শেষ মামলা হলো না সারাদিন গাদার মতো বসিয়ে রাখে
নরেন্দ্র হলো না